My lord, I want to mention for item number 22 for today's hearing.
Yes.
Yesterday, my lord, I have submitted my written argument in compliance with the last order on 21/2026. Lordship, the record make maybe tagged with maybe call for.
Arguments are not here. Arguments are at 9. You have filed it.
It is not yet tagged with the record.
Okay, you filed it
Yesterday file. I already filed.
before the registry.
Yes, yes, sir.
You should have just given it to the court master, written arguments. Anyway, yes.
Master.
May please the lordship. My lord, item number 26, my lord. Lordship was pleased to call a record. And I have received the record today, my lord. I have to go through it. My kindly accommodate, my lord.
Okay.
Put the content, my lord.
You are SP Das, na?
Yes, please, my lord.
As prayed for by Mr. SP Das, the Standing Council, DNSCT, the relist on such and such date to enable the respondent to go through the records which has been made available to him today, so as to effectively place the same on the next date of listing.
Date may be.
Your lordship, paying for listing of the matter for tomorrow, your lordship. Because
The heavy bench, na?
the senior bench is there, but lordship, that court is connected with this case, your lordship. So
Monday.
much of
May it please your lordship. Insofar as item number 14 is concerned, I am for the writ petitioner. The forest department is yet to file an affidavit, and this morning they had a talk with me that they'll be paying for time in the mention hours. Possibly he went out, you know. Could it be some other time?
You now, are you pressing that prayer on behalf of the forest
No, no.
department, Mr.
Actually,
Banik?
I was
Anyway,
considering
which
that.
is your matter?
1-4.
14.
14.
All right. We shall make you free. Heard Mr. S. Banik, Learned Counsel appearing for the petitioner, also heard, but there's no one from Forest.
I understand. Then better be called then otherwise.
Huh?
Let them come. We'll have it then.
No, you don't have to argue. You ask one of your junior to be there, then I
Very
will
well.
give that time.
Very well.
Nobody from Forest is here. How do I record someone's
No.
name? Unless you want to take
No,
time.
it's okay.
You want to take time?
No.
All right. It can accumulate like that. But remind me when this matter is called. You don't have to be here,
I'll be
Mr.
there.
Banik.
May it please your lordship. Lordship, with the consent from the petitioner, my lord, I beg to mention item number 7 from today's session.
Yes.
Here in this case, my lord, I am appearing for respondent number 3 and 4. I am seeking adjournment in this matter for today matter.
Who is there for the petitioner? Have you taken consent from the petitioner?
The consent.
As prayed for by Mr. S.
I am on behalf of Mr. N. Upadhyay.
No, your name.
S. Upadhyay.
As Upadhyay, on behalf of Mr. N. Upadhyay, Learned Counsel is appearing for the respondent number 3 and 4, with consent of the other side, relist on such and such date.
Deeply obliged.
May I please, your lordship?
Yes.
Today, I beg to mention item number 10, your lordship. We need to file our rejoinder, your lordship.
Rejoinder.
Yes, your lordship.
Have you taken consent from the other side?
No. Item
The respondents, have you informed them? You are for whom? For the petitioner.
petitioner, your lordship.
As prayed for by MS?
R.A. Chaudhary.
R.A. Chaudhary, Learned Counsel appearing for the petitioner, relist on such and such date to enable the petitioner file rejoinder against the affidavit in opposition filed on behalf of the respondent.
Review.
Inform the respondents.
Yes.
Yes.
May it please your lordship, I beg to mention my lord, item 14, my lord, I am praying for some time to file affidavit.
0.
1-4.
Yes, your affidavit was lacking in this matter. This is the Banik's matter. As prayed for by Mr. I. Thakur, Learned Standing Council, Forest, released on such and such date to enable the Forest Department file return in the matter. Which is opposed by Mr. S. Banik, Learned Counsel for the petitioner. Yes.
The interim protection used to be extended.
That is why you are you're present. Interim, if any, shall continue to the next date of listing. Yes, ma'am.
may it please your lordship, I beg to mention item number 11
Yes, what do you want in 11?
for adjournment.
You are supposed to file a rejoinder.
Yes.
So are
lordship.
you going to file your rejoinder?
We need some time.
So say that. Why are you starting with the premise that you want an adjournment? Say you want time to file rejoinder. How much time you want?
1 week, lordship.
As prayed for by MS?
Kanghon Seniority.
learned counsel appearing for the petitioner, relist on such and such date to enable the petitioner file the rejoinder in the matter. Yes, please call the list.
His lordship. Lordship, I've submitted the list of these lordship.
Yes. Before that, where is Mr. S.P. Roy? But with that item 18, the councils are there. In item 18, what about Mr. S.P. Roy? Anyone there? Anyway, you let me know whenever they are there because that judgment is already ready. So I can make you free.
Moment they come,
You let me know. Come on. In other words, you are notional seniority,
Lordship.
isn't it? That's the only limited prayer you have.
Lordship.
Yes, Mr. Gauhati, anything, I'm allowing this writ petition. Heard MS Rukmini Barua, learned counsel appearing for the petitioner. Also heard Mr. J.K. Barua, Goswami, learned additional senior government advocate for the state respondent. By filing the instant writ petition under Article 226 of the Constitution of India, the petitioner seeks modification of the gradation list of grade 3 employees of amalgamated establishment of the Deputy Commissioner Kamrup by placing his name between serial numbers 41 and 42
Lordship.
instead of serial number 114 by granting him notional seniority and consequential notional promotion on the basis of his merit, position in the selection process conducted pursuant to the advertisement dated 7/9/2007. The advertisement dated 7/9/2007 was issued for filling up of 20 posts of junior assistant, including posts under the general category. The petitioner participated in the selection process and secured serial number 4 in the merit list under the general category. Stop. Next para. During the process, counsels, please take your seat. During the selection process, this court in miscellaneous case number
2166. of 2008, Lordship. Page
Yes,
number
I've got it.
15.
2166 of 2008 arising out of WPC number 5566 of 2007, comma, by interim order permitted the respondents to proceed with the appointment process, but directed that certain posts be kept vacant pending adjudication of the matter. In consequence thereof, while 3 candidates under the general category were appointed, comma, the post against which the petitioner was otherwise eligible remained vacant. Subsequently, WPC number 5566 of 2007 was dismissed for non-prosecution on 27/4/2015 or 14?
Lordship. On 27/4/2015, Lordship.
On 27?
Lordship, page number 40, Lordship.
All right. Just check that date one.
Lordship, to 20,
I think 14.
14, Lordship.
14 because you have typed 15.
Lordship,
Anyway,
24/6.
24/6/14. Huh? Stop. Despite the interim order having ceased to operate, no appointment was offered to the petitioner. This compelled the petitioner to approach this court by filing WPC number 2504 of 2019. Stop. By judgment and order dated 15/5/2019, this judgment, sorry, this judgment is dated 15/5 or 27/4/15?
Lordship. First is, Lordship, page number 40 of the writ petition, Lordship. WPC 1012 of 2015.
Which one? How? 25? 2504 or 2509?
04, Lordship. Lordship, that's the second judgment, Lordship. First is 1012 of 2015, Lordship.
That I have. 1012, which is page 45.
Yes, Lordship.
Okay.
Page number
Okay,
40,
okay.
Lordship. 40.
তুমি কি লিখিলা কোৱাচোন মোক? Filing WPC 1012 of 2015. By judgment dated 27/4/2015, this court directed the respondents to fill up the post of junior assistant on the basis of merit under the general category pursuant to the advertisement dated 7/9/2007. Next para. As the said direction was not complied with, the petitioner again approached this court by filing WPC 2504 of 2019. Stop. By order dated 15/5/2019, this court held that the petitioner, being the next meritorious candidate after the 3 candidates already appointed under the general category, was entitled to appointment. The respondents were directed to issue the appointment order within 45 days. In compliance thereof, The petitioner was appointed as junior assistant by order dated 21/10/2019. However, in the gradation list of grade 3, employees, his name was placed at serial number 115.
114, Lordship.
114. Huh? Whereas the other appointees from the same selection process were placed at serial numbers 41 and 42 and had already earned promotion to the post of senior assistant. Correct?
Lordship.
Stop. Aggrieved by denial of seniority and promotional parity, the petitioner has approached this court. Stop. The respondents contend that the advertisement was for 20 posts and that pursuant to the interim order passed in Miss Case number 2166
Lordship.
of 2008, one post under the unreserved category and 4 posts across categories SC, ST, STP and unreserved were kept vacant. It is stated that although the petitioner stood fourth in the merit list, the first 2 candidates did not join and there existed reservation for women under the unreserved category, pursuant to which Srimati Chandana Thakuria joined service. It is further contended that promotion in grade 3 is a continuous process governed by the gradation list and category-wise reservation in the ratio of 1:4. In accordance therewith, what is the other name? MD Najrul. MD Najrul Islam and MD, the second name?
Zakir. Lordship.
Zakir Hussain and Srimati Chandana Thakuria, correct?
Lordship.
Were promoted to senior assistants. Since the petitioner joined service only on
Lordship. On 1st of November 2019.
only on 1/11/2019, pursuant to judicial orders, his case for promotion could not be considered as he was junior in the gradation list. It is thus asserted that the petitioner's placement at serial number 114 is lawful and calls for no interference. I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the parties and have perused the material available on record. The core issue that arises for determination is whether the petitioner, who was denied appointment initially solely due to an interim judicial order, and was later appointed pursuant to direction of this court, is entitled to notional seniority and consequential notional promotion from the date of his immediate juniors, from the date his immediate juniors were accorded such benefits.
Judgment, Lordship. Ba, ba. Paragraph 17, Lordship.
Paragraph
17 and 20.
Kamal, সেইকেইটা ক'ত আছে? এইটো ইয়াত আছে নেকি দেখোন? এইকেইটা check কৰিছো। The factual matrix is undisputed. The petitioner was selected on merit and placed at serial number 4 in the merit list under the general category. His non-appointment at the relevant point of time were not attributable to any fault or ineligibility on his part, but solely on account of an interim order passed by this court directing certain posts to remain, to be kept vacant. Stop. Next para. The embargo created by the interim order stood lifted upon dismissal of the writ petition in the year 2014. Thereafter, repeated directions had to be issued by this court compelling the respondents to appoint the petitioner. Ultimately, the petitioner was appointed only in the year 2019, after prolonged litigation. Stop. The respondent's justification that promotion is a continuous process and that the petitioner joined at a later stage cannot be accepted in the facts and circumstances of the present case. The delayed appointment of the petitioner was entirely occasioned by judicial proceedings and administrative inaction, and not by any conduct attributable to the petitioner. Service jurisprudence recognizes the doctrine of notional seniority and notional promotion to remedy precisely such situations. Notional promotion is granted where an employee is wrongfully denied appointment or promotion is due to circumstances beyond his control, so as to restore him to the position he could have occupied but for such denial. Though notional promotion does not ordinarily entail arrears of pay for the period during which the employee did not actually discharge higher duties, it necessarily carries seniority and all consequential service benefits. Within bracket deba, refer Union of India and others versus KV Jankiraman and others, reported in 1991 4 SSC 109. P.S. Mahal and others versus Union of India and others, reported in 1984, 4 SSC 545. Direct Recruit Class 2 Engineering Officers Association versus State of Maharashtra and others, reported in 1990, 2 SSC 715. State of Uttaranchal and another versus Dinesh Kumar Sharma, reported in 2007, 1 SSC 683. And Union of India and another versus Tarsem Lal and others, reported in 2006, volume 10 SSC 145. Sit down. To deny the petitioner notional promotion, notional seniority, merely because his formal appointment occurred later would amount to penalizing him for pursuing judicial remedies and would perpetuate the injustice that had already been acknowledged and corrected by this court through earlier orders. In Amarjit Singh and others versus Devi Ratan and others, the Apex Court reported in 2010, volume 1 SSC 417, the Apex Court has held that interim order merges with final orders, and in the event the writ petition is dismissed, interim order stands nullified automatically. Hence, party whose writ petition is dismissed cannot take advantage of its own wrong. Once this court held that the petitioner was entitled to appointment on the basis of his merit position, the logical and legal consequence was to place him in the gradation list in accordance with that merit position. Any other interpretation would render the earlier judicial directions illusory. The respondents cannot be permitted to take advantage of the delay occasioned by the interim order and subsequent litigation to defeat the petitioner's legitimate claim for seniority and promotion. Administrative convenience cannot override constitutional guarantees of equality and fairness in public employment. This court therefore finds holds that the petitioner was wrongly deprived of timely appointment solely due to a judicial interim order and subsequent administrative inaction. Upon appointment pursuant to judicial directions, the petitioner became entitled to notional seniority from the date his immediate juniors from the same selection process were appointed. The petitioner is also entitled to consideration for notional promotion if his juniors were promoted, with all consequential service benefits except arrears of pay for the notional period. I'm not allowing that because you have not worked. In view of the aforesaid findings, the writ petition is allowed with the following directions. The respondent shall revise the gradation list of grade 3 employees by placing the petitioner in accordance with law position in accordance with his merit position pursuant to the advertisement dated 7/9
2007, Lordship.
2007, that is along with the incumbents placed at serial number 41 and 42.
Lordship.
Directions is Dislana. And the petitioner shall be granted notional seniority from the date of his immediate juniors were promoted, and the petitioner shall be accorded notional promotion to the post of senior assistant if his juniors have been promoted, with all consequential service benefits except monetary benefits for the notional period. The aforesaid exercise shall be completed within a period of
2 months.
within a period of 2
60
months from the date of receipt of the certified copy of this order. No order has to cost.
45 days, because Lordship, there's a high chance of getting promoted, Lordship.
Election is election.
2 months.
Lordship. Deeply obliged.
But it is only have to be effected. Why 2 months?
Lordship,
2 months is 60 days.
Lordship, 60 days, Lordship, election, in the meantime, the election will be.
45 days.
Lordship, can it be 60, Lordship, because the election.
All right,
will
all
be-
right.
That's-
Lordship, deeply obliged.
I do not want any contempt to be filed. Huh?
that's-
I got those 2 decisions on fraud which was given. The draft. This judgment was already almost dictated completely on the other day, except that concluding part.
Yes.
I have already gone through the decisions that Mr. Roy, your junior has submitted on fraud. 2 decisions was given. I have dealt with that, and ultimately I am dismissing the appeal. Sorry. You will get the judgment today. Huh? It's already typed. There's some editing to be done. তুমি ঠিক করে পেলে মুক্তি
Order was there item number 1.
Milord, actually, by today itself, we are ready with the application. We'll file it today itself, Lordship.
Are you sure you're going to take steps today?
No, Lordship, actually, we are deleting those respondents as per last.
No,
order.
whatever. You're taking steps or not?
Actually, we are deleting those particular respondent, Lordship, to whom we are supposed to take steps. On the last date, we.
So you are going to file an application,
Today itself, we'll file it, Lordship.
an application
Yes, Lordship.
for deleting their names.
Those respondents.
So who are those respondent numbers?
17, 25 and 35, Lordship.
17? Mr. Patwari, you're appearing this matter. Though this court, sorry, though this court by order dated 11/8/2025 directed the adjourned the matter to enable the petitioner to take steps as directed earlier by this court against the respondent number 17, 25, and 35, comma. The office note dated 17/2/2026 indicates that no steps has been taken by petitioner in compliance with the aforesaid court's order. Today, when the matter is called, Mr.
NZ Chaudhary.
N.J. Chaudhary, learned counsel appearing for the writ petitioner, submits that necessary application for deleting the names of the respondent number 17, 25, and 35 is going to be filed during the course of the day. He accordingly seeks a short accommodation in the matter, and accordingly seeks good. Prayer is not opposed by Mr. J. Patwari, learned counsel appearing for respondent numbers.
Right.
Respondent number 5, relist on such and such date.
Okay.
Hey, come on. He find to draft corner, say draft record it, দেখা video. দেখা তোমার যেটা যাব খোজা তুমি যাবা সেই দুটা কাৰণে আকৌ আহিব লাগিব নহয় সো ডিটেইল লাগে কৈ দিব yes
In this case, I have to file rejoinder, but due to non-communication since long back, in this long back, I have issued a letter also. No response, and
what reply you need to file? This is a dismissal from service.
yes, madam.
So everything is on record.
But my lord,
Everything is on record.
Yes, madam.
On what ground are you challenging the dismissal? What is the ground of challenge?
challenge, my lord, after acquittal by the criminal court,
Hmm.
as per one memorandum of award,
Hmm.
one clause is there. If the person concerned dismissed without notice and subsequently acquittal on benefit of doubt by the criminal court, then the respondent should pay lump sum amount. They have paid that a minimum prayer, lump sum amount, that is also discretionary power of with the respondents. But my lord, my humble submission before this honorable court is this: whether the person concerned is alive or not, that
All
is-
right, you take your instruction. You want some time.
I have taken more time, my lord. I want to do my wakalat now, my lord, as because I am.
Then you file an affidavit, you file an application.
Yes, my lord, I am.
You don't want to pursue the case, or you have to file an application
Yes, ma'am.
because you have signed a wakalatnama, you have some responsibility.
Yes,
You cannot simply submit before the court and walk out.
yes.
You
That
have
is my
certain
lord,
responsibility under the Bar Council Act
That
also.
is-
So you
that's
do the needful. I am not recording all that.
Yes, ma'am.
Mr. V.K. Barua,
K.U. Ahmed.
Mr. K.U. Ahmed, learned counsel appearing for the petitioner, submits that due to non-communication with his client for a long time, he is unable to file the rejoinder to the affidavit opposition file on behalf of the respondent as far back as 11/1/2018. He seeks a short accommodation as a last resort to communicate with his client, failing which he shall take necessary steps to withdraw his wakalatnama in the matter. Relist on such and such date.
Obliged.
Mr. Counsel, if you have to, on this ground, you are seeking a withdrawal, then you have to enclose all those receipts that you have sent letters and you're not being able to, there is no response. You bring that.
Yes, madam.
You have some responsibilities otherwise. Yes, next.
Lordship, the required pay slip has been issued, Lordship. As per last order, 17/12/2025, court is monitoring regarding Lordship issue of the pay slip, area pay slip, and that has been issued, that has been given to us. So case may be closed, considering the order passed by this honorable court. It was retrospective benefit of promotion with consequence benefit. That has been now given.
That is given.
Now given.
So nothing survives. Heard Mr. S.K. Goswami, learned counsel appearing for the petitioner. Also heard Mr. B. Chakraborty, learned standing counsel, AG ANE Assam. Stop. The issue involved in the writ petition is grant of retrospective promotion with financial benefit to the petitioner to the post of professor with all consequential benefit with effect from 17/1/2006. Stop. Upon
Instruction.
1 second. Upon a communication dated 10/11/2025, having been placed before this court on 11/12/2025, issued by the Director of Medical Education to the Office of the AG ANE Assam, requiring the latter to issue payslip of the petitioner for the period from 17/1/2006 to 14/11/2012 for releasing to him the areas of his pay and allowances, comma, the matter was adjourned. Today, when the matter has been called, Mr. Chakraborty submits that the requisite payslip in respect of the petitioner with effect from 17/1/2006 has been issued wide, get it, Baba number 2, wide number so and so, dated 9/2/2026. A copy of the communication along with the enclosures in support of the same as received by him from the Office of the Accountant General ANE Assam, Madamgao, Beltola, by communication dated 11/2/2006 is kept on 2026 is kept on record and marked as X. That being so, nothing survives for adjudication. The writ petition stands dismissed on being infructuous.
Closed, Lordship. It is not dismissed, closed.
Is disposed of on being infructuous.
Item 4.
Huge time again to be granted because the petitioners could not come to file the affidavit.
Acha, rejoinder affidavit, Mr. Saikia.
Having their BR degree.
Rejoinder affidavit.
This is, it will be an additional affidavit, Lordship.
Huh?
And it will be an affidavit.
Additional affidavit.
My lord.
Okay. As prayed for by Mr. R.C. Saikia, learned senior counsel, assisted by Mr. J. Kalita, relist on such and such date to enable the petitioner file the additional affidavit
Affidavit in reply, Lordship.
to file their
Affidavit in reply.
reply rejoinder.
Yes, ma'am, rejoinder. Obliged.
Yes, Mr. Chaudhary.
May it please your lordship. My lord, I'll improve for disposal of the petition today, my lord. Because the issue is very small, my lord. The prayer made in this petition is for implementation of the service rules that has been, my lord, framed long time back. In fact, my lord, there is an act called, my lord, the Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996. Thereafter, my lord, the matter came up before the Honorable Supreme Court for implementation of that act. And the, my lord, Honorable Supreme Court, my lord, in 2010, my lord, directed that, my lord, the board should be, welfare board should be constituted and steps will be taken for implementation of the act. Accordingly, board has been, my lord, constituted. Then, my lord, service rules have been, my lord, framed. But the approval has not come, my lord, since 2017. And in the affidavit, my lord, they are not denying anything, my lord. They said that they are taking steps.
So rules have already been framed,
My lord.
but it is yet to be brought in force.
It has to be approved by.
So it has not come into force,
True, my lord.
isn't it?
Yes.
Unless it is approved, it will not come into
Yes.
force. So you want it to be, but how can that positive direction be granted?
My lord, my submission,
in a
to you, my
writ?
lord, that is because of the, my lord, honorable.
Yes, what is the stand of the government? Why are you taking so much time? Who is appearing for the respondent? Respondent board. Is the board here?
Yes, my lord. Board is also a respondent, my lord,
Otherwise, who will frame it? The government.
from the government in the labor department. If you
Who's appearing for the labor department? You are appearing. Yes.
and there
Why this, when was this rule framed, Mr. Chaudhary?
my lord, the rules were framed,
18,516
rules were framed in, my lord, 2014, my lord.
and adopted 1816, right?
Yes, my lord.
Correct?
Yes.
Framed on
Framed on, my lord, the rules framed, your lordship will find that at page, my lord, 60. Those are the rules, my lord.
just give me the date.
Page 59, my lord, the notification.
Twenty eleven, 2015.
2011, 2015.
2011
2015.
15
Right.
and adopted on 18,516.
Right.
Yes, we are in 25 now, 26. What is happening? Why these things, why these rules have not come? There is a Supreme Court direction also. Where is that direction of the Supreme Court?
Supreme Court's order, your lordship will find.
Miss Counsel, are you aware? Are you there in the matter? You're not saying anything.
No, Lordship.
I cannot hear you.
No, Lordship.
Then I'm repeatedly asking you. You see, if you want some accommodation, you have some problems, you will have to speak up. I cannot understand what is there in your mind. I don't know if the Mr. Chaudhary can understand, but at least I do not have such AI powers. I'm sorry, but I don't have that kind of intelligence. You will have to speak up for yourself.
Lordship, I have just now had checked the synopsis and all. So,
Mr. Goswami, why, what is wrong with the standing councils? Since yesterday, I'm noticing why fresh lawyers are being sent to the court for seeking time, for presenting the case on behalf of the government. No, this is not the first time that is happening in this court. I don't know if you were there in this court. Yesterday also for some standing council, some department. I have no difficulty if a counsel who has just entered appears in my court, but the counsel has to be fully prepared.
Yes, lordship. Lordship.
They are not being able to say anything, and that also they are representing the government, and this is a very important matter.
Lordship.
It is about framing of rules.
Yes, Lordship. Lordship, that's why, Lordship, I need some 1 or 2 days time.
So very well,
Yes,
Mr.
Lordship,
Goswami, but
that's
you
why-
were sitting there. It is not you who were on legs when this matter has been, when Mr. Chaudhary has started his argument. In fact, this court was taking it up for passing some positive disposal order.
Lordship, Lordship. Lordship. That's what, I have
You see, ultimately judicial times are
Yes.
being invested,
yes, Lordship, I will
and
take.
because of we are not, because the disposals are being slow,
Lordship,
now we are sitting on Saturdays also.
Lordship, Lordship.
But if this is the way you are going to behave, then what will be the use of sitting on Saturdays?
Lordship, Lordship.
If matters has to be adjourned only.
Lordship, Lordship, let do one thing, Lordship, can you fix the matter day after tomorrow?
There's no
Lordship?
difficulty. I said I
Yes,
can
sir.
fix it, but these things could have been said immediately.
I will appear, Lordship. I will appear in this case, Lordship.
See,
I
Mr.
will take the
Goswami, all I need to know is that how much time you need to bring this rules. That's
Yes,
all.
sir.
I am otherwise, if you cannot come up with that instruction, then this
Then
court
I-
knows what is to be done.
Yes, I will come.
And Mr. Chaudhary, I would request your junior to just give a small list of dates and the pages where these, at least these 5-6 annexures which you are relying. It only will help the court to give the dictation immediately on that date.
Right.
And that Supreme Court judgment, you said something is there, right?
Yes.
From where, is that available in
Yes.
the file? Which
Yes.
page? I'll just flag it.
Starts at page 29.
Page?
Page 29.
Page 29 is a this is an extracted copy. This is not a judgment.
Sorry, my lord, please, it starts at page 32. 31. 31.
30,
31.
31.
Page 31.
Okay. So I'll have it when, Mr. Goswami?
Any date, lordship, day after tomorrow, next week, any date, lordship.
Tuesday? Monday, Tuesday.
Lordship.
I'm keeping it on Tuesday so that you give that note on Monday.
Yes, lordship.
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel appearing for the petitioner. Also heard Mr. J.K. Goswami, Learned Senior Assistant Senior Additional Senior Government Advocate for the state respondent. Mr. Chaudhary submits. I'm saying it's part heard then.
Lordship, lordship.
Anyway, Mr. Chaudhary submits that the issue involved in the writ petition is non-action of the respondent government, respondent state for bringing the Assam Building and Other Construction Workers Welfare Board Service Rules 2014 in force, despite the same having been framed way back on 2011-2015 and having been adopted by the respondent number 4 by notification dated 18/5/2016. Mr. So-and-so, Learned Additional Senior Government Advocate, seeks a short accommodation to apprise the court as the time frame by which the said rules can be brought in force.
Lordship.
Released on such and such
My lord,
date.
may I pray that Mr. Goswami's name be shown in the court?
Yeah,
please?
no.
Yes, yes.
So, Lordship,
Mr. Let the name of Mr. So-and-so for so-and-so be reflected in the cause list.
I will do, lordship.
Now you have no escape route.
I will do.
Mr. Chaudhary is ensuring that.
Yes, lordship. Obliged.
Item 6. Lordship, in this matter, I pray for letting recommendation for today. Mr. D. Upamanyu has been, Lordship, taking care of this matter, Lordship.
All right.
The
Upamanyu-
always this submission is made, this matter is very urgent, my lord.
What is it?
76 years old, my lord, no pension, nothing, my lord. Am I deplorable condition I'm there, my lord.
76 years old. But the only thing is that D. Upamanyu is regularly appearing. Today he's saying having some problems. I'll have it on Monday.
Tuesday, my lord.
Tuesday, all right. Because you see, there's, no, that's all right.
sorry, Lord.
Heard Mr. B. Chakraborty, Learned Counsel appearing for the petitioner. Mr.
A.R. Tavinda.
A.R.
Tavinda.
Tohilda, Learned Counsel submits that the conducting counsel on behalf of the Higher Education Department, Mr. D. Upamanyu, is having certain difficulty today and seeks a short accommodation. Though considering that the issue involves non-payment of pension to the petitioner who is aged about 76 years, reluctantly the prayer is the matter is posted on such and such date. However, no further adjournment shall be given. Family pension.
But I am deprived of the pension on the basis of the revised scale of payment.
Yes, health and family, Mr. Chalia.
Lordship, here, Lordship, I have received an instruction here. The issue is, Lordship, the department is seeking for some time because, Lordship, the records have been misplaced, Lordship.
What
This
has
is
been misplaced?
The records, Lordship, because
Records.
look, I think the petitioner is receiving some family pension, Lordship, but they are asking for a revised pay scale. Now, for that, we have to enter into the record, Lordship. I have an instruction.
All right, all right. How much more time you need
Lordship,
to
now the
trace out the record?
yes, Lordship, because it's from Buxa and it's like 14 years old, Lordship, the PPO, Lordship.
But you don't need 14 years to travel to Baksha.
No, Lordship. Here I'm asking for 3 weeks, Lordship. 3
3
weeks.
weeks, my lord,
Lordship,
3 weeks is, in today's time, 3 weeks is quite a lot.
No.
But considering that the records have
Records
been,
are in Lordship.
Mr. Chaudhary, we might need some time to trace it back. And we will give you some time, but this is the last opportunity you'll be getting. So do whatever you want to do to unearth your records.
Yes, we have communicated, Lordship.
And communication is no good, Mr.
Yes,
Cholia.
Lordship, we are trying because the
Communication is no good.
Yes,
It is only piece of paper in your file.
Yes,
The
Lordship.
records has to be traced up.
Yes, Lordship.
There has
That
to be
is-
some action at
Yes,
Baksha.
we have written to the AG also.
Heard Mr. D. Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. A. Chalia, learned standing counsel, Health and Family Welfare Department. And you are there, Miss?
I'm appearing for BTC authority.
MS?
And so,
And Chaudhary, learned standing counsel?
yeah.
Learned standing counsel BTC. And you are there? MS?
Accountant General
MS?
A. Sharma.
MS A. Sharma, learned standing counsel AG and AE. Correct?
On behalf of.
All right, your on behalf, you keep on giving it. You are here, we don't know who on behalf you're appearing. And then you say, Mr. Chalia, with profuse apologies, submits that despite best efforts, the records are not being able to trace out. However, seeks a short accommodation in this regard. Prayer is not opposed, released on such and such date.
Won't be heard of.
You have sufficient
Lordship,
time.
Lordship. We'll make sure.
In this case, madam, I am appealing for the respondent number 6, 7, and 8, madam. So what happened, madam, I have filed the affidavit in opposition, but so for annexing some documents, some wrong was there, my lord. So that
Sorry,
was-
sorry.
I have filed the affidavit, my lord, for respondent number 6, 7, and 8, my lord. But so far, my lord, annexing some documents which are relevant to this case, my lord, that has been wrongly, my lord, tagged, my lord.
That has been inadvertently
My lord,
brought on.
bottom, my lord,
So now you want time to bring the relevant documents.
in a proper manner.
By last order, my lord, the record was called for, my lord. So
You have the records.
But that has been, my lord, taken by the, my lord, block of the officer, my lord.
Why?
My lord, that has been lastly, my lord, called for through the, my lord, government, my lord. No, I got it earlier, I said.
6, 7, 8.
Earlier, occasion-
Managing committee was directed to produce the
Yes,
proceeding
sir.
record.
So what happened then?
the last,
That
last.
to be
occasion.
produced by.
My learned friend is supposed to.
Yeah, my lord,
Councils, please maintain the
Yeah.
decorum of the court.
Madam, may
You
I
all are
explain?
turning it into some fisherman's market now. Three of you pointing
Yes,
to
I'm-
each
I'm-
other.
I'm-
Okay, so I am giving you the time. You,
Right.
you file whatever correct annexures you want to file, and I will say on the next date, you will have the records available. So get the records from
Yes.
wherever you have to get
Right.
it. Heard Mr.
Jiuddin.
Chiuddin, learned counsel for the petitioner, also heard Mr. M.K. Sharma, right? M.K. Sharma, learned counsel appearing for the school managing committee of Jadavpur MEM School,
Right.
R 6, 7, and 8, and Mr. P or B? P.N. Sharma, learned counsel appearing for elementary education. You're standing counsel, right? Standing counsel elementary. Though by order dated 8/1/2026, the school managing committee, respondent school managing committee was directed to produce the original records of the managing committee before this court. However, on call, Mr. Sharma seeks further time for placing the same. He further submits that that while filing the affidavit in opposition on behalf of the respondent number 6, 7, and 8, inadvertently wrong enclosures have been crept into the said affidavit, and accordingly prays liberty to rectify the same. Relist on such and such date, by which date the respondent number 6, 7, and 8 shall file an additional affidavit along with annexures, if so advised, and needless to be clarified that on the next date of listing, the respondent number 6, 7, and 8 shall positively have the original records of the managing committee as called for earlier by this court by order dated 8/1/2026. You are going on submitting. My court master has already given a date. Why are you not attentive in court? Huh? You go on submitting.
All right.
Yes, Mr. Bora.
My lord, I filed an IA, my lord, against the interim order.
What, Mr. Bora?
For in modification of the interim order, my lord. And the page, my lord, 20, my lord. How to put this? People.
Yes.
Let page 21, my lord. The order has been passed. Against the mind that I was appointed as a headmaster of ME school, my lord, and thereafter my learned friend client filed a petition, my lord, and Honorable Court Height order dated 19/12/2024, my lord. In the interim, the order dated 13/12/2024 issued by the in charge district elementary education officer Lakhimpur, allowing the respondent number 6 to hold the current charge of headmaster in charge of Suwansri Sewa Ahar ME school, Lakhimpur shall remain suspended till next date, my lord. And pursuant to Honorable Court's order, my lord, the inspector of schools
This is holding charge.
holding charge, just in charge the headmaster, my lord.
And you are who?
I am the assistant teacher, but though I am the junior to him, my lord.
Then what right do you
Right,
have?
my lord, this there, my lord, he has not acquired the eligible qualification.
This is not a regular appointment. This is a stopgap arrangement in charge. What is wrong in this?
My lord,
This is only the issue is not decided.
Yes.
This is only in the interior.
Stopgap, my lord, for the purpose of stopgap, my lord, director limited education appoint me, my lord, as a in charge headmaster, my lord.
Mr. Bora, there's an in charge appointment.
And the main issue is
You are junior to him.
junior, just junior, but higher qualification, my lord,
This
because
is
of
not regular appointment, Mr. Bora.
my lord.
This is not a regular appointment.
But regular appointment is considered 2 years, so the mandatory for the 2 years, the.
That is regular.
Regular. my
This
lord.
is not regular appointment. Admittedly, you are junior to him. If this in charge was given to him, then Mr. Pegu would have been standing the other side. You are for the private respondent.
No, no. He's the
In fact,
writ
I'm a
petitioner.
writ petitioner, my lord.
So you are the writ petitioner.
Yes, my lord. I was appointed as a my lord.
Who was given the appointment?
I was given the appointment.
He was given.
So you are rightly Mr. Pegu was then standing.
Yes. My lord.
So in your writ, you have been now allowed.
Yes, my lord, in fact, my lord, despite of
What is the stand of the government?
Yes, my lord, this is required.
The stand of the government is that qualification, right? The private respondent number 6 was having due qualification. And moreover, lordship, now the process of regular headmaster appointment is underway. So the proposal has already been submitted to the government for appointing regular headmaster. So this is only a in charge headmastership. Now, in charge headmastership was given to the respondent because he was more qualified than the petitioner. Only on that ground that.
Any authorities, Mr. Bora?
Yes, my lord.
If
Authority means, my lord, I am the
any authorities, give me any authorities. If you have, I'll vacate it then right away.
my lord, that is the. but
You've
my-
come for vacation.
Yes, my lord. As per my lord, your lordship go to the page annex of 14, page 38.
Is that an authority? I've understood that
as
you are
per-
more qualified, you are junior.
Yes, sir.
Yes.
As per NTC, my lord, and class 6 to 8, my lord, BA, BSc, 2-year diploma elementary education. He is only 6 months. I am more than 2.
I've understood that. It's undisputed that you are qualified.
My lord, my lord.
Now, for in charge,
My lord, let them, my lord, the inspector is.
I'm asking you if you have any authority in support of your contention.
My lord,
If you have it, say yes. If you don't have it, say you don't have it now, or that you may.
You may submit, I may be allowed.
Correct. So just, but you see, now I cannot be prompting you to say
Yes,
what
sir.
you, what is to be said before the court. It is
My-
for you to decide that.
My lord, that I am going to.
So what do you want, Mr. Bora?
Next week, I will.
So you get hold of that decision. There are, I think, two decisions, most likely one from this court also on in charge.
My lord.
I've forgotten the name.
Next week.
Have it.
My lord.
Heard Mr. N. Bora, learned counsel appearing for the petitioner. Also heard Mr. J. Payang, learned counsel appearing for the petitioner. Mr. Bora seeks how much time? Accommodation to place the authorities on the issue as regards the right of the qualified in support of his contention that the in charge appointee must possess the requisite qualification.
I'll submit, but in fact, there is no requisite qualification. In the qualification, it is not necessary that he must be B.Ed. That is not, the government of Assam has circular and the rules. Is
But Mr. Sharma was also saying that he is qualified.
He is higher qualified. Higher qualified, not the basic. The requirement is not.
Where is the requirement? Show.
As per NCT reports, my lord.
No,
The NCT. my-
One second, I cannot hear both of you
My lord,
together.
my
One,
lord.
just one indicate, where is it?
My lord, if your lordship may see my writ petition, my lord. My writ petition, my lord.
Yes, where?
Yes, it is
Writ
in
petition, yeah.
page 22.
Yes,
Page 22, my lord. Page
yes.
22, Page 22. Para 5 may be seen, my lord. The teachers who have passed at least metric.
Mr. Pego, you are the senior one.
Yes, my lord.
You're the
Yes.
petitioner is the senior.
Senior one, yes. That is admitted question, ma'am. The teacher who have passed at least metric, HSLC, normal or have the at least intermediate or equivalent qualification or above have successfully
Which part are you reading?
Para 5 months.
Yes.
The teachers, 10 years minimum, my lord, teaching should be there.
Who have passed at least metric, HNC normal or have at least intermediate or its equal qualification.
Or above have successfully undergone necessary training as may be prescribed by the department shall only be considered for promotion. However, teachers who have completed minimum 15 years of
15 years
continuous service, but no facilities have been provided him or her for present training may also be considered for promotion to the post of.
So you are
I'm a higher secondary pass HSS.
HSLC.
Yes, HS, higher secondary.
HS.
Yeah, HS. And I have my training which was provided as per direction of the government of Assam.
So you come under the however part.
No, both my lord.
Both
In fact, I have
HS
training
and you
also.
have training.
Training.
So you have completed training.
Training, 6
of-
months training as per the government's direction, my lord. I was sent for training by the department. Then even then also, my lord, I completed more than 23 years, my lord, in service.
How much?
2001, I was
More than
more than 23 years. 2001, I joined.
23.
23 years.
Yes.
2001, I joined, man.
Okay. And what about you?
He joined in
Hey, my lord.
2009, man.
I'm DLED 2 years and also completed B.Ed and MA also, my lord.
Okay.
Well, as per my lord,
Right, Mr. Bora, I am dismissing the interrogatory application right now because this is, I thought they do not have the requisite qualification. That's why I wanted that case law, but it's not a case of that. It's a case of who is better suited.
Yes.
That objective criteria cannot be gone into at this stage. It's not a regular appointment.
as per my lord.
I'm sorry, Mr. Bora.
NCT, my lord,
You
regulation, my lord.
complete your submissions. Anything more?
Yes, NCT, my lord, regulation, my lord, class 6 to 12, my lord, BA, BSc and second year diploma, has 2 years diploma in elementary education. He has an intermediate, my lord. I am also, my lord, degree bachelor as well as 2 years diploma as well as B.Ed also.
All right.
My lord, so my lord, as per NCT, my lord, Act, my lord, they provide that this is a requirement.
Okay.
Page 43, my lord.
Page 43 of the writ petition.
Yes, no, ma'am, IA, my lord, IA, my lord. IA.
All right.
My lord, your lordship go to class 6 to 12, my lord, Roman 2A, my lord.
Page 43,
Page 43, my lord.
class 6 to 8.
My lord,
Yes.
BA, BSc and second year diploma in elementary, so whatever, my lord.
Yes.
Or BA, BSc with at least 50% marks. My
Okay.
lord. 1 year, my lord. But that he has only 6 months. And on the other hand, my lord, if you
Very
go
well.
to my lord, page 46, my lord. Right to education also 2-year diploma is required, my lord. Page 46, my lord.
Yes.
My lord, court fera, my lord.
Yes,
Now,
I've seen. Yes,
now-
I've seen.
now, therefore, in exercise of power conferred by the
2-year diploma in elementary education by
my-
whatever
my-
name known for appointment of a teacher in class 1.
and
Yes.
1-year bachelor education or B.Ed for appointment teacher in class 6 to 8, my lord.
Yes.
This is the school is 6 to 8, my lord.
Yes.
He is the intermediate, though he is a senior. I cannot, my lord, the admitted position, but he has not, my lord, qualification for that.
Okay.
my lord. This is my humble
Very
submission.
well. What do you have to say, Mr. Payang, to the NCT?
We have own rules, my lord. Government of Assam has own rules. This is part of the rule. A rule has says, my lord, this is minimum qualification. In fact, this is for, my lord, this is for promotion to the post of headmaster, not for appointment, my lord,
This is promotion.
to the post of headmaster. My case, my lord.
All right.
And our appointment were met, my lord, in 2001. My appointment. The NCT guideline, my lord, it is for the appointment at this stage.
This is 2010.
Yes,
Okay.
2010. In fact, this is in 2022. This is again notified, my lord. The please 20.
All right. Take your seats.
My lord.
Heard Mr. N. Bora, learned counsel, appearing for the applicant. Also heard Mr. J. Payang, learned counsel, appearing for the respondent number, stroke writ petitioner, and Mr. B. and Sharma, learned P. N. Sharma, learned additional standing counsel, elementary education, so and so. Respondent to DDMA. By way of this interlocutory application, comma, the applicant is seeking vacation, modification, alteration of the interim order dated 19/12/2024, passed by this court in WPC number 6875 of 2024, whereby the respondent authorities were directed to allow the applicant to hold the charge of, no, 1 second. Whereby the writ petitioner was allowed to hold the charge of in-charge headmaster of Swansea.
That's one of 6 allowed.
No,
Page
No,
54,
my lord,
my lord.
the fact of the case, my lord, initially I was allowed by the
I'm mentioning about the order.
order, my lord, initially.
I was appointed.
By the court's order.
Court order.
Wiki will likhila. Alter the interim order passed
Maybe.
by this court. Where is the court's order?
Page
Page-
21.
The court's order is allowing Mr. Payang's client, isn't it? The writ petitioner. I'm mentioning that fact.
No, page 21. my lord.
Page 21. Whereby in the interim, the order dated 13/12/2024 issued by the in-charge district elementary education officer Lakhimpur, allowing the applicant to hold the current charge of headmaster in charge of the Swansea Siva Ashram ME School Lakhimpur was suspended till the next returnable date. So now no one is holding it?
No one, my lord, inspector school running down.
That's why, my lord, my prayer earlier occasion. In fact, this matter has listed for admission column. So there was a prayer that the entire matter may be, my lord, that was.
I think that would be appropriate because Mr. Boram, I was thinking he is running it. That is not because then there's no point of keeping the post vacant right now.
Yes.
Someone has to man it.
Yes.
Well, let them file government affidavit is required, my lord.
You have not filed affidavit in the main petition. Why?
Affidavit has not been filed, instruction received lordship. And according to my instruction, because you are as required, that is now we have.
Mr. Payang, I'm vacating the stay.
Yes.
I'm vacating your stay. Because it can, somebody has to man it. Otherwise he has a qualification they have already appointed. You as a writ petitioner, you don't have a right to that in charge post. We will see when the main case is taken up.
Initially, my lord, your lordship will see, my lord, in my writ petition.
But you see, it's not a question of who is best suited right now.
Yes, I'm
Correct.
not on that, my lord.
Now, the government has appointed Mr. Bora's client. Mr. Bora's client is otherwise eligible. He is not an ineligible person. He may be junior to you.
Yes.
Your whole case is that he is junior to you. That's it.
I'm also eligible, my lord.
Correct. But just because you both are eligible doesn't mean that the government cannot appoint someone else.
No, my lord, if your lordship may kindly see, initially my lord, if your lordship may kindly see, page 16 of my writ petition, my lord. This was for the inspector of schools, my lord. Earlier, the inspector of school has given a direction to the retired headmaster.
It appears that the entire matter is required to be heard is required to be heard. Let the government file their return in the main matter within a period of 10 days from today. Upon filing of the affidavit of the government, the writ petitioner shall file its rejoinder within a period of 7 days thereof. After 17 days of the date, relist on such and such date, on which date an endeavor shall be made to dispose of the entire matter. Follow the timeline.
Yes. If they file my letter. All right.
Item 13. Earlier occasion, my lord, BTC took time for my filing affidavit.
Praying for some more time to file affidavit for respondent number 3 and 4. Instruction is with us, lordship. 2 weeks time, we'll file.
As prayed for by MS so-and-so, released on such and such date to enable the respondent BTC to complete return in the matter.
May I prefer date?
19 of March.
Item 15.
Yes, Mr. Cholia.
In this case, I have filed an application. Some typographical mistakes cropped up, my lord, at paragraphs 3, 4, and 5 of the petition.
You want to make those changes? We'll have it.
Amend the same, and I'll file an amended petition.
All right.
Thereafter within 7 days.
Oh, this is an interlocutory
Right,
application.
my lord, yes.
Okay.
I filed in the petition.
Mr. Talukdar, any objection?
No.
Heard Mr. DP Cholia, Learned Senior Counsel, assisted by MS M. Roy, Learned Counsel for the petition applicant. Also heard Mr. B. Talukdar, Learned Standing Counsel, Elementary Education. By the instant application, the applicant is seeking modification, correction, rectification, alteration of typographical error, which has inadvertently appeared in the paragraph 3, 4, and 5 of the writ petition, i.e. WPC 558 of 2025. It is stated that while filing the writ petition, in paragraph 3, 4, 5, it was inadvertently typed. That the petitioner is receiving salary up to 2020, has received salary up to 2023, whereas she received her salary up to 2003. Similarly, in paragraph 4, it has been inadvertently stated that the petitioner has been paid his salary up to 2002, but it was wrongly mentioned as 2022. Similarly, in paragraph 5, it has been wrongly stated that the petitioner has been paid his salary up to 2002. Wrongly stated that the petitioner has been paid salary up to 2022. Into 8 asylum. Having heard the learned counsels appearing for the parties and having perused the averments made in the interlocutory application, it appears that certain errors have been crept into the paragraphs number 3, 4, and 5 of the writ petition, which requires to be modified which requires correction in the interest of justice. Accordingly, the application stands allowed. Let amended writ petition be submitted before the registry for doing the needful.
And finally, within a week.
Within a week.
Till 16.
File challenging the appellate order in a disciplinary proceeding.
Yes.
I think the affidavit is required.
Huh?
I think the affidavit is required.
Mr. Talukdar, you are not in the mood of filing any affidavit.
My lord, recently my lord, I am for the respondent number 1, my lord, and his appointment was under Assam Sarva Shiksha Abhijan, my lord, and he was terminated by the mission director Assam Sarva Shiksha Abhijan, my lord. So that's why Sarva Shiksha Abhijan will continue.
Yes, Mr. Nayak.
And this is the last day.
No, are you all not filing any return in this matter?
This state concept, the order which is under 7th document is an order passed by the
Commissioner, my lord.
Secretary of the Government of the Department of School Education. So this is in terms of, that is why I am thinking that the.
Who will be the appropriate respondent?
Litigation.
But Mr. Talukdar is not in the mood.
My lord, I find my lord, that's I just indicated my lord.
No, if you want, you file.
My lord,
Or I hear now. You want me to take it up now?
my lord, I
Uh,
allow.
Heard Mr.
MJ Kadir.
So-and-so learned counsel appearing for the petitioner. Also heard Mr. B. Talukdar, learned standing counsel,
Elementary
elementary
respondent
education,
number 1.
and for respondent number 1, and Mr. P. Nayak, learned additional advocate general for as a standing counsel.
Yeah.
And
That's one number 4.
for
6 and 7.
respondent 4,
6.
6, and 7. Mr. Talukdar seeks a short accommodation to complete to file return in the matter. Prayer is not opposed, released on such date.
23rd.
I think 17.
May I please, your Lordship? Lordship, as per the last order, Lordship, today is the date fixed for consideration of my interim prayer, Lordship. I am
Lord-
taking honorarium of 17.
Lordship, here in this case, Lordship, so for my limitation is that Lordship, the instruction has not received till now, Lordship, can you fix the matter that in the any date, Lordship, next week, Lordship, or any date, Lordship, then in the meantime, we will receive the instruction, Lordship.
Non-payment of honorarium to the petitioner since February 2021.
Yes, Lordship, may kindly come to the last page, Lordship. Page 33, last paragraph.
Yes.
Last paragraph, Lordship, page number 33, last paragraph. This is a communication from the respondent number 4 to respondent number 1 to pay the honorarium of Anganwadi worker. Requesting.
Yes.
Last paragraph, Lord.
Yes.
Considering the above decision by the Honorable Gauhati High Court, it is requested that Srimati Jyotika Das Anganwadi helper be allowed to continue serving as an Anganwadi worker as per the previous order of her promotion. It is also requested that she be permitted to draw the honorarium of an Anganwadi worker with immediate effect for the sake of natural justice. It is important to note that 88 Nang Singrimari Koliasuba Anganwadi Center is currently functioning without an Anganwadi worker, and Srimati Jyotika Das is already discharging the duties of an Anganwadi worker.
This is by the Office of the Child Development Project Officer.
Yes, to the response number 1, Lordship.
Lordship, here in this case, Lordship, on 19/01/2026, Lordship, the notice was issued, Lordship. This, your Lordship will, Lordship was issued the notice. We received the copy of the service copy on 11/02/2026 only. Therefore, Lordship, we are not.
Okay,
getting
we'll
the
give you
instruction.
some time
Yes,
then,
Lordship.
but you see, I do not understand why this has not been paid. There is a positive direction.
Yes, already.
All that you need to is pay it. So
Yes.
you get that instruction.
Yes.
You don't need a detailed affidavit in this matter, Mr. Agaswamy.
Lordship.
So by when can you give that information? At 2 o'clock?
No, Lordship, next week, Lordship, we
That's
received.
the information it's required.
No, Lordship, the.
The only information required
the
is
service-
when
Service
I
copy.
have understood.
Received on
I have
11
understood
only.
your service copy and all that. You need the detailed, all that only if you have to file a return.
It's
Right
true,
now, I'm only on the small issue.
Lordship.
How much time do you need to
Next
release
week, Lordship,
the?
any date. Next week, any date, Lordship.
Call them
No,
up.
Today is.
You
Thursday,
have
Lordship.
smartphones, Mr. Goswami.
Yes, Lordship.
You just
Next
have
week,
to
any-
dial the number
Monday,
of the
Lordship.
concerned person.
Monday, Lordship.
Monday.
Monday.
Heard Mr. P. Majumdar, Learned Counsel, appearing for the petitioner. Also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate, appearing for all the respondents. While issuing notice on 19/1/2026, upon considering that the present petition that the present petitioner is assailing non-payment of honorarium of the petitioner since February 2021, was pleased to direct consideration of the interim at the returnable date, which is at the returnable date on the next date of listing. Today, when the matter is called, Mr. Goswami seeks short accommodation for filing return as the service copy was received by his office on 11/2/2026. Noting that the Office of the Child Development Project Officer, Kwalkusi ICDS Project, Bongshar Kamrup, by letter dated 1/9/2025, has already requested the Director, Women and Child Development, Assam, Ujan Bajar, Gauhati, to allow the petitioner to continue serving as an Anganwadi worker as per the previous order of her promotion, and that she be permitted to draw the honorarium of an Anganwadi worker with immediate effect for the sake of natural justice, and that 88 number of Singimari Kalya Chuba Anganwadi Center being currently functioning without an Anganwadi worker, the presence of the petitioner, who is already discharging her duties of an Anganwadi worker, is of utmost importance. This court directs so and so to apprise this court on the next date of listing as the time frame within which the honorarium of the petitioner can be released. The areas, no? By the time frame within which the honorarium of the petitioner, I think, isn't it, can be released. Stop. in the, let instructions be placed in this regard on the next date of listing.
Supplementary list, item number 30.
In this matter, we need some time to file the affidavit. We have not received the instruction.
Instructions.
Yes, we have not received the instruction.
All right, Mr. Kalita, na?
Yes, Lordship.
Let them complete the instruction. Heard
Lordship,
Mr.
Only one thing there, Lordship. The petitioner was suspended on 31/2017, Lordship, and thereafter he was acquitted in the year 2025, Lordship, January 2025. Till date, he was not reinstated, Lordship.
Instruction will be required 25 on
Heard Mr. K. Kalita, learned counsel appearing for the petitioner. Also heard Mr.
A.R. Prohibitions.
A.R. Tovilda, learned counsel appearing, standing counsel,
Higher education.
learned standing counsel, higher education. And Mr. J. Patwari, learned counsel appearing for respondent number 3. Mr. Tavildar seeks short accommodation to file return in the matter. Prayer is allowed, relist on such and such date.
20 of February.
Hello.
26th of February. March.
March 26.
Yes, Mr. Khatuniar,
Yes.
what is this review?
Yes, ma'am. I'm seeking a review of an order which was passed on my lord 7/2/2017, my lord.
Where is the order?
My lord will find the order at page 110, my lord.
Yes, what is 110?
Yes, my lord.
This order,
Yes, my lord.
2017.
17, my lord. The only ground for review, my lord, admittedly, my lord, the petitioner initial appointment was irregular appointment. So
Sorry?
initial appointment was illegal appointment, my lord. But somehow she got salary up to 2007. Then salary was stopped. She filed writ petition. Then writ petition was allowed.
Mr. Khatuniar, I don't need to remind you of the limitations in a review jurisdiction. Review is not for rehearing.
I'm just giving a background of the fact.
Before you take me to the background, what is the error committed in this judgment?
There is
What error is the error which has to be apparent on the face of the record?
Yes, my lord. Subsequently, she participated in a screening process, and that screening process, finally, the petition was given a fresh appointment in the year 2020. That is why, my lord, we are seeking review, because those illegal and irregular teacher of Dhemaji and other districts, my lord, pursuant to order of this honorable court, a screening committee was constituted in the year 2012, and she participated in that screening process. While this earlier petition was pending, she participated in the screening process, and pursuant to the screening result, my lord, that was placed before the cabinet, and cabinet took a decision to accommodate those teachers prospectively according to their qualification.
So she is one of them.
She is one of them.
You are for the?
I'm for a state, my lord.
No, but then how does this judgment get affected?
So, since subsequent committee identified her as a illegal or irregular teacher and gave fresh appointment, and in this judgment, my lord, impugned judgment, there's a direction to make the payment, my lord.
Payment of what?
Salary.
So because that part, salary for the period she's working, and you must have already made that salary.
No, my lord.
Given, not given.
No, not given, my lord.
8 years has been elapsed, my lord, from the date of the judgment, my lord.
Paragraph
In the
17 of the
meantime, she
judgment, my
retired from
lord.
the
Paragraph
service.
17.
Yes.
Accordingly, and in the light of the above, it is hereby directed that present petitioner would also be entitled to her salary from August 2007. The respondents are directed to release the current salary of the petitioner, that is salary for the month of February 2017, within a period of 3 months from the date of receipt of the certified copy of the order, and the arrears salary from August 2007 to January 2017, within a period of 4 months.
And I think similar judgments were also there, but those are different petitioners.
Different petitioner.
My lord,
The only thing is that, my lord, those were also appointed with the same appointment. letter.
Has the court come to a finding that your appointment is not illegal? Is there
No, my
any
lord.
finding?
No, my lord.
Then-
No such finding.
Then,
In this,
then.
no such finding.
You are only saying that that now that she's an illegal appointment.
Yes, my lord.
But there's no such finding here. Why should we disturb this judgment?
There is no such finding in
Then why should we disturb this judgment? Tell me that.
the only thing, my lord, she herself subject to the same screening process, which was
And you have
undertaken.
selected her. And you have selected her.
Yes, my lord. We have verified the documents. And the
I'm
genuine
sorry,
test-
Mr. Khatani, I'm not being able to understand what is exactly that you want. Because if in the order of this court passed on 7/2/17 does not have any finding as regards your appointment, then what is the error that you need this court to correct? The court has only held her liable for the salary. That's it.
Yes,
That's it.
but our predicament is that, my lord, since
I cannot, this is not a rehearing,
that I understand, my lord.
not a rehearing. You think about what I'm trying to say. You have anything to support yourself on because sometime on a subsequent fact, yes.
It's a subsequent fact, my lord.
That's why I'm saying there could be a ground for review, but that subsequent fact has to have some bearing in the. I'm not trying to. I'm not being able to perceive that link right now. So you have to impress the court on that. So and get hold of those decisions.
Yes, my lord.
On subsequent facts.
Yes, my lord.
Because just merely because she has participated and she got selected, how that would make this order of 7/2/2017 bad? Because if I have to review this order,
Yes, my lord.
this order has to be, I have to touch this order,
Yes,
correct?
yes,
I can only touch this order if I find that there is an error. She was not a selected candidate on 7/2/2017.
Not. It's not.
She was not a selected
It's not a
candidate. That day there was nothing like this happened.
On that day, yes.
Later on participated. Now she got selected or whatever you're saying.
Yes, my lord.
So that-
She was
So this
identified
is
as an illegal.
a subsequent thing.
Yes.
How that would make this order bad? You are asking me to exercise review jurisdiction on that basis.
Yes.
I don't think a case is made out. I can dismiss it right now. I'm giving you some time.
Yes, my lord.
You look into it. I really don't think.
I'll try to
that
find out.
the
my lord.
rate- You may have a point in what you're saying, but that can be read in some other way. I don't think review would lie.
Yes.
Yes, Mr. Maheshwari.
My lord, what happens, my lord, whatever my learned friend is trying to submitted, my lord, nothing was mentioned except personal knowledge. No document has been exhibited
Where nothing was
in the
mentioned.
review. No document. Everything was verified to the.
Anyway, I'm not
My lord.
disposing it out right
My
now.
lord.
So let him
My
be
lord,
more
I was
prepared on the
probably-
next day. You save your energy for the next date,
No, no,
Mr.
my lord, I'm
Maheshwari.
keeping the other way, my lord. What is the problem, my lord?
Hmm.
2017 order has not been complied with till today, my lord.
Mr. Counsel, have you filed a contempt?
My lord.
Is that contempt before me
Contempt is before your lordship.
today?
Yes, second item.
Yes, well, contempt is there, my lord.
No, contempt is.
That is there, my lord, in the same file. That is why, my lord, what is the?
No, wait 1 second.
Man.
So the stand you're taking in the contempt is the review is pending. And when did you file this review?
25, my lord.
Last year.
And the order of the court is of 2017.
My lord.
Have you filed your affidavit or not
No.
in the contempt?
No. Affidavit filed, but not counter affidavit. That is different.
Explain the reason, my lord.
No. nothing was explained.
Mr. Khatuniar, I will take it up on the next date.
Yes, my lord.
Both matters for hearing.
Yes, my lord.
So you be prepared. The
Yes, ma'am.
contempt also is not, if this court finds that you've been deliberately not doing it, then this court will not hesitate
Yes, madam.
to pass necessary orders. I'm telling you.
Yes, madam.
Madam, may I
Merely because a review is filed and even that review doesn't look meritorious to me. You look into it.
In the last order.
The 7/2/2017 order is very clear. The salary should have been paid. What is your stand in the, in your affidavit in the contempt?
Nothing.
In contempt, my lord, because all writ petition contempt are tagged with a series of matter, my lord. So it was not in the notice of the department. Only in the year 2024, when the matter was segregated, then it came to our notice, my lord. Then we have filed a review petition. So that explanation we have given in the affidavit, my lord. Since 2018, my lord, it was tagged with a batch of writ petition, which is pertaining to the illegal and irregular appointment of Dhammaji district.
When do you want it?
Next week, my lord.
Heard Mr. N.J. Khatoniar, it reviewed Diba, huh? N.J. Khatoniar, Learned Counsel appearing for the review petitioner. Also heard Mr. A.K. Maheshwari, Learned Counsel appearing for the respondent. Mr. Khatoniar shall apprise the relist on such and such date.
Because the after I shall remain out of the question.
Next week or the date did you? তেখেত ক'ৰবাত বাহিৰত যাব।
Wednesday.
25th.
26.
Wednesday.
Mr. Khatoniar, you look into it. I do not see any merit in your review.
Yes, I'll try to find it. 24th. Obla Judge.
Here, my lord, earlier, my lord, my learned friend filed a writ petition. My lord, that was 2803/21.
Respondent number 7, who is appearing?
No, sir, I am appearing.
You have received notice?
Yes, yes. But my respectful submission is that my learned friend is seeking modification or review of the disposal order that was passed in the writ petition, which was filed by me. That was disposed of with certain directions to pass a speaking order. Until the passing the speaking order, that interim order passed earlier, that will be continued. Now, my filing this IA, my learned friend is seeking review of that order. Probably, Lord, this is not the proper application. He should file a review application, Lord. So
IA for review.
Yes, Lord, he is seeking the
My lord,
modification of the final
Lordship,
disposal order. Lord, may kindly
By
skip
filing an IA.
IA.
How can that be
Yes,
done?
Probably
my lord,
not maintainable, Lord.
my lord.
Lord, sir, kindly
Lordship
come to.
will-
Are you, this interlocutory application is for modifying a
No, my
direction?
lord, only for vacation of interim order, though my, whatever, my lord.
Just kindly see the.
Vacation of interim order of what? Of a disposed of writ petition?
Yes, my lord.
How can that order be vacated? The
Please.
order has already merged into a final order, Mr.
Yes.
Counsel.
Yes, my lord. That order was for interim, my lord. That is why, my lord.
Mr. Counsel,
Lordship will.
the writ petition has been disposed of?
Yes, my lord.
Very well.
My lord.
I'm sorry, nothing survives. You cannot file an interlocutory application for vacating a stay order in a writ petition which the writ petition has been disposed of, Mr. Counsel.
My lord, only lordship may peruse the order. If my not.
What is there to be perused? The writ petition has already been dismissed.
My lord-
The orders that are passed have already merged into the final order. Have you challenged the final order?
My lord, I have not challenged the final order because on lordship may peruse only page 54, my lord. Thereafter, what will be decided?
Page
lordship, that's all.
50?
My lord, page 54, my lord.
Yes.
Here, my lord, only thing. That is. Writ petition are disposed of by certain.
Yes,
order.
I am in page 54. Please
My lord.
point out. Let us not waste more time of the
My lord,
judicial, more judicial
My
time on
lord, in
this.
last in page 53, my lord, paragraph bottom, my lord.
Yes, till the appeal is disposed of, the interim order that so and so passed by this court shall continue.
Yes.
Yes, what is this?
My lord, here is direction is given. The petitioner is directed to file an appeal before the secretary to the government of Assam.
Very well.
Page 53, my lord.
Education Department, so and so within a period of 10 days from today, thereafter, on receipt of the appeal, the respondent number.
Have you challenged this order? Have you challenged this order 17203? You have not challenged. Have you filed a vacating order of 17/2/2023 or a review order? Have you filed a review against the order of 17/2/2023? You have not done it.
Yes.
You have not done it. Very well. Now take your seat. You have other remedies available. You exercise whatever remedies are available under the law. This is not the right way. Your name, please. Heard Mr. M. Hussain, Learned Counsel, appearing for the applicant. Also heard Mr.
A Dekal,
A. Dekal, Learned Counsel, appearing for respondent number 7.
7.
And who else are there? Mr. Talukdar?
I'm for 1 and 2.
1 and 2. Mr. Chalia? 1, 2, and 3. Mr. Chalia? Oh, you're not there. Government? Mr. Goswami, you're there?
6.
6. If anyone is left out, just give the name to the court master.
I can't commit to the government. No, 2 1 to 5. To me, 1 to 5.
By way of this interlocutory application, the applicant is seeking vacation of the ad interim order dated 12/7/2021 passed by this court in WPC number 2803/2021 on the purported stop. It appears that WPC 2803 of 2021 has already been disposed of by this court by judgment and order dated 17/2/2023. The operating part of the judgment reads as under A to A, page 53 plus page 54. There is no appeal or review against the aforesaid judgment and order dated 17/2/2023 passed in WPC 2803 of 2021. However, by filing the present interlocutory application, the applicant is seeking modification of the interim order dated 12/7/2021 passed in the aforesaid writ proceeding IWPC 2803 of 2021, purportedly on the ground that the same is being directed to be continuing till disposal of the appeal. Upon hearing the learned counsels appearing for the parties and having perused the material available on the record, it appears that the present interlocutory application is for vacating a stay granted by this court in a writ petition which has already been disposed of. That being so, the present application is meritless inasmuch as there is no challenge to the final disposal, judgment and order. That being so, the I stands dismissed.
Only one statement recorded. That my final order, the writ petition has not followed that order.
I've already said it till that appeal part.
And
yes, dictated already. Yes, next.
Liberty is given to my lord afresh.
No liberty. I'm not. You should know what is available in your in law. You should have thought about it before filing this interlocutory application. You are fortunate that I have not imposed any cost. Yes, next. Yeah, change.
My lord, this is an appeal, first appeal, my lord, filed by me, challenging the judgment and decree dated 15/5/2023.
This is that case.
That
Your main contention is
No,
that there is an agreement to sale and that sale agreement does not confer any right, title, interest. This is number one.
one.
Number two is that after the judgment of the trial court, the part of the land has a part and portion of the land has been acquired,
By the
and therefore the specific performance has been barred. Correct? This was your main submission, if
No.
I remember.
Yes. Now,
Yes. You want to
another-
improvise it? Yes, you
Yes.
can go ahead.
Yes.
But I am trying
Not
to.
bury it, my lord.
I am just trying to recollect what had
Yes,
happened on
yes.
the last occasion
Now-
because
Now
yes,
to merit, my lord,
yes.
this suit for specific
Right.
performance of
We
contract,
draw material here.
my lord, this suit for specific performance of contract is not maintainable in view of section 34 of the specific relief act as well as order 7 rule 1 of the CPC, my lord.
34
34
and
and order 7 rule 1.
yes.
Now kindly see the plaint, my lord. Why I am saying that it is not maintainable? That part I am coming to the plaint from plaint. Page 8, my lord.
Yes.
Page 8. Plaint.
Yes.
Worship got it?
Yes. Yes.
May I read the plaint?
Yes, please.
Operative part I am reading. Paragraph 10. Page 10. That all on a sudden the defendant had decided unilaterally. Paragraph 10.
Yes.
That all on a sudden the defendant had decided unilaterally not to sell the scheduled land to the plaintiff without any reason and execute a deed of contract with the plaintiff on 15/2/2019, which the defendant assured to return rupees 31 lakhs to the plaintiff within the month of April 2019 as per bank rule, with interest permission by the bank. The plaintiff have no option but to sign the deed for fear of losing such a big amount paid to the defendant. It is also assured by the defendant by the deed dated so and so that in case failure on the part of return of rupees so and so within the month of April 2019, he is bound to execute a registered sale deed as per agreement dated 2/2/2017 in favor of the plaintiff. So my humble submission that he has not challenged in this case regarding 15/2/2019 agreement, on the basis of which the earlier agreement was cancelled, my lord. Now kindly see the prayer part. Prayer part. So until and unless they can, yes.
Yes.
Now kindly see prayer part.
Yes.
Under such circumstances, next page.
Yes.
It is prayed that your honor may be pleased to decree the suit with cost by directing the defendant to execute and register the sale deed in favor of the plaintiff in respect of property actually described in schedule below on acceptance of balance amount of rupees so and so within a time specified by the court, failing which the sale deed be executed and registered so and so. So only enforcement of earlier agreement, that is agreement dated 2/2/2017. Now until and unless this subsequent cancellation agreement is under challenge, this suit is barred under section 34 of the specific relief act because he has not sought any declaratory relief against that agreement subsequently which has been made. That agreement was nothing but a cancellation agreement. To that respect, my lord, I have the authority, my lord. Here I am showing AIR 2025 SC 1806. Here in this case, if seller is unilaterally cancelled, then also declaration is required under section 34.
Yes.
Paragraph, kindly see, my lord, page 20, page 9 of this judgment. This is Supreme Court judgment, my lord, recent judgment. Absent a prayer, page 9, paragraph 23.
Yes.
Absent a prayer for declaratory relief, that cancellation of the agreement is bad in law, a suit for specific performance is not maintainable. This, the court further find, this was the question. The court further find that seller had admittedly issued letter dated so-and-so, cancelling the agreement to sell dated 25 January 2008 prior to filing of the subject suit on 5th May 2008. Even though the demand draft enclosed with the letter dated so-and-so were subsequently encased in July 2008, yet this court is of view that it was incumbent upon the respondent number 1 buyer to seek a declaratory relief that said cancellation is bad in law and not binding on the parties. For the reason that existence of a valid agreement is sine qua non for grant of relief of a specific performance. This court in so-and-so, this is held that in absence of a prayer for declaratory relief, that the termination of agreement is bad in law, the suit for specific performance of that agreement is not maintainable. Though subsequently, this court has held that the declaration of law so-and-so regarding non-maintainable of the suit in the absence of challenge to the letter of termination is confined to the fact of the said case, yet the aforesaid issue has been recently considered in so-and-so, this judgment has been, it has been clarified that appellate court would not be precluded from examine whether the jurisdictional fact exists for grant of relief of a specific performance, notwithstanding the fact that the trial court omitted or failed to frame an issue of maintainability. But in this present case, maintainability issue was framed, and that was decided against us, against the defendant, in favor of the, without considering that aspect of the prayer, that subsequently agreement was cancelled, and court, this trial court held that there was no pleading to that effect that subsequent agreement was cancelled. But it is the pleading of the plaintiff himself in the plain. That is why I have shown the paragraph 10 of the plain. So ultimately, this Supreme Court held that, consequently, this court is of opinion that absent a prayer for declaratory relief, page 11, that termination, cancellation of the agreement is bad in law, suit for a specific performance is not maintainable. Now, this.
So this 31 lakh was given back or not given back?
Not 31 lakh. There was amount was fixed 31 lakhs.
Yes.
Amount
Was given back or not given back?
No, 16 lakh, as per their version, 16 lakh is yet to be.
You see, because if I'm now going by para 10.
Yes.
What does para 10 says? Para 10 says that the all of a sudden the defendant had decided unilaterally not to sell the scheduled land to the plaintiff without any reason and executed a deed of contract with the plaintiff on 15/2/2019.
Plaintiff was
Which,
signatory. Plaintiff signed that.
I've understood. I've understood.
Yes.
Which the defendant had assured to return rupees 31 lakhs
Yes.
to the plaintiff within the month of April 2019 as per bank rule. That is with interest permission by bank. The plaintiff had no option but to sign the deed for fear of losing such a big amount paid to the defendant.
Yes.
It is also assured by the defendant by the deed at 15 to 19 that in case of failure on his part to return rupees 31 so and so within the month of April 2019, he is bound to execute a registered sale deed as per agreement dated so and so in favor of the plaintiff.
Yes.
Para 11, that as the defendant had failed to return rupees 31 lakhs to the plaintiff within the stipulated time of April 2019, the plaintiff had sent a notice to the defendant on so and so to execute a registered sale deed.
Yes.
So here, this is the facts in your case. This is the admitted facts
This is
in
the
your
admit-
case.
yes.
All right.
Now, question is, in the written statement, I specifically admitted that I am ready to willing to pay the refund the
Very
amount.
well. Very well.
In the written statement, it is there.
Very well.
Now, question is, once the agreement was cancelled by the subsequent agreement, until and unless that was challenged, the plaintiff is not entitled for a specific performance of contract. However, with respect to the refund of money, because I have admitted that yes, I am ready to return the money, so it is entitled. He is entitled. I am not disputing with respect to that. Because since I have admitted in my written statement, I am still ready and willing to refund the amount.
Very well.
So until and unless that subsequent cancellation is under challenge, suit for a specific performance is not maintainable. So under such circumstances, this judgment is liable to be reversed by allowing the judgment.
All right.
This
Yes.
is in merit with respect to. Now kindly see the judgment regarding maintainability part. Trial
Mr.
court.
Ghosh, do not repeat your argument because I have
No, I'm
heard
not
you.
repeating.
Otherwise,
I want to show
if
only
you want
maintainability.
if you want to show addition like you have just pointed out this point, it will be appreciated. Otherwise, on those two issues, do not
No,
repeat
issue, I
the
want to
earlier
say-
issues about that agreement to sale and the
No, not that issue.
yes,
Page 34, judgment,
yes,
trial court judgment.
30,
34,
yes,
whether first issue, whether the suit is maintainable. What
yes.
the court has been decided. Because since I have challenged all the first appeal, my lord, from the pleadings of the parties, it appears that though the defendant alleged in his written statement that suit is not maintainable against him.
Where are you reading?
Page 35,
Yes,
issue number 1.
yes. Yes.
From the pleadings of the parties, it appears that though the defendant alleged in his written statement that the suit is not maintainable against him, but no evidence to that effect was adduced. On the other hand, from the materials available.
Just 1 second, Mr. Ghosh. Yes.
The defendant failed to perform, it is found that the plaintiff alleged that despite entering into agreement dated so-and-so to sell the suit land to her, and despite receiving an advance amount of rupees so-and-so in total, out of consideration amount of rupees so-and-so, the defendant failed to perform his part of the contract and execute the registered sale deed in her favor. On the other hand, it is found that defendant has admitted the contract and receiving rupees so-and-so, but he alleged that the contract was between him and the son of the plaintiff, and he received the aforesaid amount in advance from the son of the plaintiff. Further, from the pleadings of the defendant, it appears that he denied to have failed to doing his part of the contract. Therefore, considering the rival condition, I find that there was a genuine cause of action for filing the suit in favor of the plaintiff. Moreover, from the record, it is found that suit was filed on 12/7/2019, and admittedly, the contract was initially entered on 2/2/2017. Therefore, it is found that the suit filed within the period of regarding limitation period. So, with respect to subsequent cancellation, that has not been discussed in this point while deciding the maintainability issue. So there was an error. The evidence,
Mr. Ghosh, what I'm not being able to appreciate that part of your argument is, yes, you have rightly pointed out from those decisions of the apex court that in a situation where you have cancelled, that cancellation needs to be specifically put to challenge. Unless there is a declaration to the effect that that cancellation is bad, subsequent consequent reliefs cannot be granted. There is no quarrel to that proposition. But in order to apply those principles to the facts of your case facts has to be seen, right? Now, the undisputed position in your case is that you got an agreement executed by them after the sale to agreement that you are going to return the 31 lakhs and you are not going to go ahead. However, there is a rider there that this 31 lakhs would be given to them on a particular date, within a particular date. In the event you do not give it, then that will not be treated as cancelled. This is the admitted position, which you are also not denying. And it's also admitted that within that time that you agreed in that agreement, you could not return that 31 lakhs. Now you are saying that later on you are willing, you are ready and willing. I understood. But as per that paragraph 10 conditions, as per of that contract which you had with the defendant, with the plaintiff on 15 to 19, you were required to return 31 lakhs within the month of April 2019. And if you fail to do so, you are bound to execute a registered sale deed as per the earlier agreement, that is 2/2/17 in favor of the plaintiff. This is what is the pleading, because you are relying on paragraph 10. So I have to read para 10 as a whole.
Yes.
I cannot be reading what is in favor of you and only take that, correct? Now, when we read, we further go down in paragraph 11, they have clearly given this averment also,
Yes.
that you have failed to return that 31 lakhs. Now, Mr. Ghosh, unless you try to understand what the court is, what is going on in the mind of the court, you will not succeed in your arguments.
No.
Because you have to convince the court, Mr.
Yes.
Ghosh. You may be well prepared, you might know more than the court, but at the end of the day, the court has to author the judgment. So I am only asking these questions to get the answers from you. Don't get intimidated just because the court is posing the questions. Now in paragraph 11, they have clearly said that 31 lakhs has been failed. You have failed to deposit. Now, given that situation, where is the occasion for the plaintiff to challenge this cancellation, the agreement of 15 to 19, or for a declaration that this agreement is bad? Because on its own, because you did not pay, it has got cancelled. You don't need any declaration. This is what is my first reading. I understand that now you're ready. I understand that later during your evidence stage, I understand.
Leaving that part.
Yes.
What is the agreement about?
Yes.
Kindly see the agreement.
Which agreement?
That cancellation agreement.
The 15
No,
to 19?
Yes.
Yes.
Now, may I read that agreement?
Yes. Where do
Yes.
we get that agreement?
It is in the record.
Dioxanator.
That is very important.
Exhibit 20.
Please take it out, Mr. Datta. Just take care of Dio. Flag it, that agreement. Anything else from the trial court records you want to rely, you can get it flagged. I can, so that we don't have to pass it.
No.
Anything else you want to rely from that file?
Yes. Agreement. First agreement.
And
then second agreement. Both agreement.
Mr. Datta flagged both the agreements.
Both the agreement. First,
One sec.
Yes.
Let me have it. You are in a hurry.
No, I am not in hurry.
I understand the lunch break is approaching.
No, I am not in hurry.
Mr. Nath, I will not have time for your matter now. You can come back at 2 after this. there are no index. Kamal, দুখন কাগজ ভালকে চাই লৈ আহিব।
Can I read operative part?
Yes.
Because the pleading part which has been stated,
No, whatever you want to rely.
yes.
Yes.
Second page.
Yes.
দ্বিতীয় পক্ষৰ পৰা লোৱা আগধন
Yes.
অৰ্থাৎ টকা বেংকত নিয়া অনুসৰি নিৰ্ধাৰিত সময়সীমাৰ নিয়ম অনুসাৰে তৰত টকা 2019 তাৰিখৰ এপ্ৰিল মাহৰ ভিতৰত ঘূৰাই দিম বুলি বাধ্য হৈছো। অন্যথায় পূৰ্বৰ চুক্তি বাহাল ৰাখি দ্বিতীয় পক্ষৰ পৰা পাব লগা বাকী টকা আদায় লৈ উক্ত টকা মাটি বিক্ৰী কৰিবৰ হেতু অনুমতি পত্ৰ দ্বিতীয় পক্ষৰ পৰা উক্ত মাটিৰ সম্পূৰ্ণ ধন আৰু স্বত্ব সমঝাই দি মাটি বিক্ৰীৰ দলিল পঞ্জীয়ন কৰি দিবলৈ বাধ্য হম। Now there is a rider that if I fail to make the return, then he will make the remaining balance amount to me. Then I will execute the sale deed. That is readiness and willingness. In the plain, nowhere stated, nor in the evidence that he is offer me remaining balance of rupees so and so, and I had to execute the sale deed. That part is not pleaded in the plain.
What about their notice, that 13,519? Where do I get that?
Now, my lord, that I will come, my lord.
No, where do we get that
Notice.
notice?
It was exhibited.
Where?
I'll flag it.
13,590. I want to see that.
Notice.
Yes. Where do we get that?
Exhibit 21.
Exhibit
21.
21.
Yes. Next page, I think.
Huh?
After this agreement, I think. Because this is exhibit 20.
It advocate notice. But it a code permit. The page numbers would be
I'll find out, my lord. I'll find out.
It is dated 16/3/21, na?
Yeah.
It should have been here only, but I find the immediate page is 13,519. Is the
13,519.
that is the notice?
Yes, yes.
Are you sure? Because here,
Yes, I have stated in my plain
okay.
that the plaintiff had sent a notice to the defendant on 13/5/2019. So
You have a copy? You have a copy of this notice or not?
No. Okay.
You have a look at it. It is here.
No.
This is given by you, isn't it? To Sarudun Ali is you.
Yes.
That an agreement for sale of the land described in the schedule below was executed by you with my client duly so and so for consideration, so that my client had paid the said amount amount to you by collecting from different sources with much difficulty with the hope of purchasing the land, that my client is always ready to perform her part of contract by paying the remaining amount of 16 lakhs to you, but all of a sudden you decided unilaterally to sell the scheduled land to my client without any reason and executed a deed to this effect on so and so before so and so with assurance to return so and so to my client within the month of April 19 with interest which you bind yourself to execute a registered sale deed as per agreement 2217. That you have failed to return the said amount to my client nor execute a registered sale deed till date, and as such my client has reason to apprehend that you had executed the deed of agreement for sale so and so, that you are legally bound to obtain permission for sale of so and so and to execute for the ground stated this notice and so within a month from the date of receipt of the after obtaining permission for the and by taking the remaining amount of rupees 16 lakhs from my client ready to pay by her. So that has been
That is the
indicated,
statement.
failing which
Yes.
my client shall. So immediately that, no,
But-
because you made a submission just now that this was not
I have
shown.
made a submission on the basis of agreement. That
No, but the
agreement.
notice, in the notice she has given
He
her.
has given that subsequent part, that
that
after obtaining sale permission, he will ready and willing to pay the amount.
No, because in the initial part also it
No,
said.
initial part is prior to cancellation part. Initial
Okay.
part is prior to cancellation.
Hmm.
Now, with respect to first agreement, my lord,
Hmm.
because
Yes, what do you want to show from the first
first
agreement?
agreement, kindly see, from first day he has on the last day he argued regarding part performance. Part performance. First agreement is an unregistered agreement. Kindly, this part performance has come from the TP Act, my lord. Section 53A of the TP Act. Kindly see the section 53A of the TP Act.
Hmm.
This concept has come from this provision, this part performance part.
Right.
53A, kindly see.
Yes.
Where any person contract to transfer or consideration of any immovable property by the
ना सर ये रास्ते में कौन बोल
TP Act.
I have
TP Act.
oh TP Act
TP Act.
section
53A. Where any person contract to transfer for consideration any immovable property by writing signed by him or on his behalf from which the terms of necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding where there is an instrument of transfer that the transferee has not been completed in the manner prescribed therefore by the law for time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee, and person claiming under him any right in respect of the property on which the transferee has taken or continued in possession other than his right expressly provided by the terms of the contract. So possession is the sine qua non for performance of the part performance.
what is the sine qua non?
That possession, that on enter into agreement, possession has been handed over, but registered sale deed has not been done.
Here position was not given.
Not. Now, kindly see the Registration Act, my lord. Why I am saying that Registration Act? This part performance is, this agreement was signed in 2017. And in 2001, Registration Act has been amended by which this section, compulsory registrable part, is incorporated by way of amendment in Indian Registration Act. Earlier, this part was not registrable. Indian Registration Act.
1 second.
Yes.
So here you are the transferor.
Yes,
He is the transferee, isn't it?
yes.
So the provision of section 53A recognizes a right of a transferee where a transfer has given and the transferee has taken possession.
Yes.
Now here the transferee has not taken possession. But this does not bar specific performance of contract. That is independent.
That I am coming, my lord, that judgment I have coming, that was also a discretionary power under section 12 of the
No,
specific
that would be under that particular act, isn't
yes.
it?
Now kindly Indian Registration Act.
Hmm.
No,
So
I am saying
one
that
by one, now your reliance on this section is for what? What is
this
the
is for this section in the specific relief act, the doctrine of part performance has came from this transfer of property act. Because how the transfer of property part performance is to be done, that is specifically mentioned in TP
But
Act.
however, now in a situation where a specific performance is sought in a suit, that would be governed irrespective of whatever is laid down in the TP Act, isn't it?
Yes.
It has to be under the provisions of the Specific Performance Act. Correct?
As well as TP Act. Because it is a transfer.
Now, what is the condition there in the TP Act? That he has to be in possession.
Possession is to be given.
Unless he has possession, he cannot enforce part performance.
Part performance. Only with respect to part performance. Even then, suppose it is not there. Then also kindly see Indian Registration Act, section 17, 1A. Section 17, 1A.
Yes.
Lordship got it?
Yes.
This was, this amendment has incorporated in 2001.
Yes.
The document containing contracts of transfer for consideration any immovable property for the purpose of section 53A of the TP Act shall be registered if they have been executed on or after the commencement of the Indian Registration Act and other related law amended so and so. And if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of section 53A. And heading kindly see paragraph 17, section 17, document which registration is compulsory.
So this right to agreement was not registered.
Not registered.
Therefore, you're saying it's not enforceable.
Not enforceable. Now, kindly see the agreement, my lord.
Yes.
Whether in the context of Indian section 12 of the Specific Relief Act, whether that clause is separable or not. That is
Yes.
another argument. After
Yes.
can,
Yes, we will
Yes.
resume at 2.
yes.
এইটো বেলেগকে কৰি দিয়া না, এইটো কনফিউজ হৈ গ'ল এইফালে গোটেই খেলি মেলি হৈ যাব এইটো লৈ লৈছোন
These arguments are on merit.
Mr. Ghosh, it will be possible for you to ask your office to just translate that particular relevant portion of that agreement?
Today may not.
Correct, but that
Yes.
particular part
Yes.
that you are relying.
Actually, I supposed to submit the agreement, both the agreement is to be translated
It would be,
in
it
total.
would be probably we will finish the
Otherwise-
arguments today, but because they have given a written argument. A copy has
I'll
been
submit-
given, so you also
yes.
submit, maybe let us see
Let-
how we finish today.
Yes.
And then maybe you can supplement that by a written argument as well as the translated
Translate
copies
copy.
of those
It
two
is
agreements.
actually required.
I think it would be better.
It is required.
It would be better.
Yes. My lord, yes, sir.
Yes, please.
My lord, kindly see the exhibit 21, the notice. I have flag mark, my lord.
Yes, 1 second.
Once again, notice. In the C file, my lord, the original is in the C file, my lord.
C5.
Yes. Because they are evidence and original records are kept.
Yes,
Page exhibit 21.
yes,
Only single page has been exhibited.
yes.
And actually, the operative part of this exhibit, my lord, it has not been exhibited. Now kindly see D file, my lord. In the D file, second page is there. I have flag mark.
Yes,
Last portion, my lord.
yes.
In this exhibit, nowhere he specifically stated as per the second agreement that take the amount of rupees 16 lakhs and to execute the registered sale deed. Rather, it says that take permission, then registered, then at the time of registration, it take the money. Now, the readiness and willingness is the main concept.
What is, can you read that agreement again?
Yes,
The second agreement.
second agreement.
Not the second agreement, sorry. Read that,
First agreement.
then your cancellation notice.
Yes, second agreement.
That is the second agreement. no?
Second-
Just
second.
read that part again.
Yes. দ্বিতীয় পক্ষৰ পৰা পোৱা আগধন অৰ্থাৎ টকা বেংকৰ নিয়ম অনুসৰি নিৰ্ধাৰিত সময়সীমাৰ ম্যাদহাৰে নিয়ম অনুসাৰে অৰ্থাৎ টকা 2019 চনৰ এপ্ৰিল মাহৰ ভিতৰত ঘূৰাই দিম বুলি বাধ্য হৈছো। অন্যথাই পূৰ্বৰ চুক্তি বাহাল ৰাখি দ্বিতীয় পক্ষৰ পৰা পাব লগা বাকী টকা আদায় লৈ
But that means that after you pay, they will pay that, I think.
I will execute this sale deed.
No,
No, দ্বিতীয় পক্ষ is they.
understood.
Yes.
But you see, as per the first agreement, they were not supposed to pay the entire amount at one go. They were supposed to pay 31 lakhs, right?
No, that I will come, my lord.
No, I am just trying to
Yes.
understand the terms and conditions of the agreements. Let us
Second,
understand
yes,
it.
yes.
It has been said.
Second agreement.
Correct. And now in the first agreement, the terms of payment is 2 installments. Is it not?
No.
It's not 2 installments,
Not two
31
installments.
lakhs and then
No,
the
no.
remaining 16
First
lakhs.
agreement, I will come first
You
agreement. Not
please indicate me what is the terms of the payment.
first
Okay,
agreement.
first agreement.
Yes. First agreement, exhibit 1.
You just read out that part. What is the agreement? What is the how was the
Terms of the first agreement.
transfer supposed to?
Yeah. প্ৰতি কাঠা মূল্য চুক্তিসমূহ প্ৰতি কাঠা মূল্য 20,000 টকা হিচাপে প্ৰথম পক্ষই বেচিব বিচৰা 2 কাঠা 7 লেচা মাটিৰ মূল্য 47 লাখ টকা ধাৰ্য কৰা হ'ল। প্ৰথম পক্ষই বেচিব বিচৰা মাটিৰ পৰিমাণ তাতকৈ কম বা বেছি হলে সেই হাৰতে মাটিৰ দাম দ্বিতীয় পক্ষই প্ৰথম পক্ষক আদায় দিব। অগ্ৰিম ধন 10 লাখ টকাৰ ভিতৰত অগ্রিম ধন 10 lakhs 7,50,000 টকা 2/2/17 তারিখে প্রথম পক্ষক আদায় দিয়া হল।
That has been already given.
On the day of execution. আৰু বাকি থকা 2,50,000 টকা অহা 1 মাহৰ ভিতৰত দ্বিতীয় পক্ষই প্ৰথম পক্ষক আদায় দিব। Next, third, বাকি থকা 37 লাখ টকা
30 means
37 lakhs 37 লাখ টকা কিস্তি হিসাবত সুবিধা মতে প্ৰতি 1.5 মাহৰ মূৰে মূৰে দ্বিতীয় পক্ষই প্ৰথম পক্ষক আদায় দি থাকিব। Fourth, উক্ত বিক্ৰী কৰাৰ বাবে বিভাগীয় কৰ্তৃপক্ষৰ পৰা প্ৰয়োজনীয় নথিপত্ৰ সংগ্ৰহ কৰাৰ খৰচ প্ৰথম পক্ষই আৰু পঞ্জীয়নৰ দলিল সম্পাদন কৰাৰ খৰচ দ্বিতীয় পক্ষই বহন কৰিব পাৰিব। প্ৰথম পক্ষই দ্বিতীয় পক্ষক মাটি সমজাই দিওঁতে তাত থকা কুৱাটো বাদে বাকী সকলো স্থায়ী অস্থায়ী গাঁথনি বা ঘৰ আঁতৰাই সম্পূৰ্ণ পৰিষ্কাৰ মাটি দখল দিব। That means clear vacant possession will hand over.
Free of income.
তাৰ আগতে চৰকাৰী কৰ্তৃপক্ষৰ দ্বাৰা প্ৰথম পক্ষই বেচিব বিচৰা মাটিৰ সঠিক সীমা উলিয়াই দি চৌহদ্দৰ পাকা বেৰৰে সীমা নিৰ্ধাৰণ কৰা দ্বিতীয় পক্ষক প্ৰথম পক্ষই সহযোগিতা কৰিব। That means boundary before execution of deed, boundary wall is to be erected by clearing the vacant possession. এই চুক্তি ভংগ কৰি প্ৰথম পক্ষই ভৱিষ্যতে অন্য কোনো লোকক তপশিল মাটি বিক্ৰী কৰিব নোৱাৰিব আৰু উক্ত মাটিৰ মূল্য কোনো কাৰণতে বৃদ্ধি কৰিব নোৱাৰিব। এই চুক্তিপত্ৰৰ বিপৰীতে উভয় পক্ষৰ কোনো ৱাৰিছ কোনো প্ৰকাৰ ওজৰ আপত্তি নাই আৰু কৰিলেও আইনমতে অগ্ৰাহ্য হ'ব। এই চুক্তিপত্ৰৰ দফাৰ কোনো কথা কোনো পক্ষই ভংগ কৰিলে ভংগকাৰী পক্ষ আইনমতে জগৰীয়া হ'ব। This is
So
the first agreement.
total consideration is
47 lakhs.
47,
Yes.
out of which admittedly 31 is paid.
Paid.
So balance is 16.
Balance is 16. Now,
Now, what I still couldn't understood when you're reading it, this entire 47 lakhs is to be paid by when?
that specific mention
Is
in
not
first
there.
agreement
Is
not,
not there.
But in second agreement, specific mention has been given.
Now come to the second.
Second. That means second cancellation agreement. Here in this case, first party is Shodudon. I am the first party. Second party is the appellant, that is plaintiff, respondent. দ্বিতীয় পক্ষৰ পৰা লোৱা আগধন তাত 70 টকা বেংকৰ নিয়ম অনুসৰি নিৰ্ধাৰিত সময়সীমাৰ নিয়ম হাৰে নিৰ্ধাৰিত টকা 2019 চনৰ এপ্ৰিল মাহৰ ভিতৰত ঘূৰাই দিম বুলি বাধ্য হৈছো। Then stop. অন্যথায় পূৰ্বৰ চুক্তি বাহাল ৰাখি, that means earlier agreement will prevail. দ্বিতীয় second party পৰা পাব লগা বাকি
That means
টকা
notwithstanding the terms, or what does that means if you translate that part you just read?
yes.
As-
অন্যথায় otherwise the earlier agreement will prevail over and পাব লগা বাকি টকা and দ্বিতীয় second party will pay the remaining balance amount.
Mhm.
Then stop.
That is after you, in case you fail to give them the 31.
Then he will have to pay 16 lakhs, another 16 lakhs.
In
Chukti-
terms of the first agreement, it is
Yes.
said that
No,
in terms, no, but that has to be in terms of the first
no,
agreement.
earlier said it will prevail over the first agreement.
Correct.
Yes.
Prevail over.
Yes.
That means the first
অন্যথায়
huh?
অন্যথায়
Means
Otherwise.
irrespective of what is stated in the first agreement.
Yes.
No. What does it mean? Exact translation would mean, Mr.
অন্যথায়
Ghosh?
পূৰ্বৰ চুক্তি বাহাল ৰাখি
That means keeping the,
yes
if
keeping
I have
the-
understood, 'cause
Yes.
so that means both are in
Yes.
existence.
yes.
So keep,
ৰাখি দ্বিতীয় পক্ষৰ পৰা পাব লগা বাকী টকা আদায় লৈ ও উক্ত মাটি বিক্ৰী কৰা হেতু অনুমতি পত্ৰ লৈ দ্বিতীয় পক্ষৰ উক্ত মাটিৰ সম্পূৰ্ণ দখল আৰু স্বত্ব সমঝাই দি মাটি বিক্ৰীৰ দলিল পঞ্জীয়ন কৰি দিবলৈ বাধ্য হ'ম।
you do give me the translated copy,
Yes.
but what I understand, Mr. Ghosh, subject to correction, is that this is all a continuing thing, because now that you have failed to give it back after after the second agreement that you entered with him, where you said, all right, I'm giving you, I don't want this sale transaction, I will return you your money. But there was a condition that, however, if I fail to return it within this particular time, then this agreement will become useless, and that first agreement will also stay, and accordingly you have to give your remaining payment, and I have to complete the procedures and give it to you. This, in nutshell, I think it means that only. So I really don't see Because if right now, I'm sure you are trying to build up a case for that point, that you are by relying on those decisions of the apex court, you want to say that declaration should have been there. For I think for that you are, isn't it? So there I'm having a little bit, the rest of the arguments, what you are saying is making, I am with you at this moment. From that transfer of property and all that. But here I am having a little difficulty in accepting your argument, because my understanding is you have not returned. So that second agreement goes. Nonetheless, the first agreement stays, and under the first agreement, they definitely have to pay you your balance. But that doesn't mean that you will not do your part. You will have to also do your part. And under the first part, there was no time limit. Ki on that particular day, this money has to come. They have, out of 47, they have given 31. Now you do your part and they will do it.
Now, my lord, kindly see once again the prayer in the plaint.
Yes.
Prayer in the plaint.
Yes.
Page 11.
Page
11.
11.
Under the circumstances.
One second.
Yes.
Of the plaint, na?
Plaint.
Yes.
Under the circumstances laid above, it is prayed that your honor may be pleased to decree the suit with cost by directing the defendant to execute and register the sale deed in favor of the plaintiff in respect of the property, actually, not properly described in the schedule below, on acceptance of balance amount of rupees 16 lakhs within time specified by the court, failing which sale deed be executed and registered according to the provision of Order 21, Rule 34 of the Code of Civil Procedure, and also give a relief so and so. Now, kindly see Specific Relief Act, Section 29. When a suit for specific relief performance is prayed for, my lord. Section 29.
Yes.
Section 29. Alternative prayer for rescission in a suit for specific performance. A plaintiff instituted a suit for specific performance of contract in writing may pray in alternative that if the contract cannot be specifically enforced, it may be rescinded and delivered up to the council.
A plaintiff instituting a suit for the specific contract in writing may pray in the alternative that if the contract cannot be specifically enforced, it may be rescinded and delivered up to be cancelled. And the that part is not there. Huh? That's what you want to say. And the court, if it refuses to enforce the contract specifically, may direct it to be rescinded and delivered up accordingly. Okay.
Now, the argument which has been made regarding Section 12. Now I am coming to Section 12 of this Specific Relief Act. Here in this case, my lord.
So the prayer in this plain is, I think it is there in alternative also.
No prayer.
Failing which?
Failing which?
The sale deed be executed. And registered according to the provisions of Order 21.
This is regarding execution of sale deed.
So they don't have the alternative prayer.
They don't have the alternative prayer.
So here, but here that, see, not because of not seeking an alternative prayer, obviously the suit cannot fail. The suit cannot be failed because of that, isn't it? Here they have only prayed for specific performance. Yes. That is the only prayer. And the trial court has granted it.
Yes.
Now, this court, while sitting, while exercising the powers jurisdiction under the first appellate, as a first appellate court, cannot say, ki, no, your suit is defective because you did not
That-
make an alternative prayer.
That is first argument I have made, that it is not maintainable.
Because of
One aspect, that section 34, relief has not been, the
declaration.
declaration. Number two, that is I am coming, number two, no
929.
alternative prayer has been made.
But for that, how is the suit going to be
Yes,
fatal?
that I am coming, that I will come.
It's an alternative prayer. They don't want to make an alternative prayer. Now, can you force them to make the alternative prayer? See, I could have understood that in the absence of the alternative prayer, the trial could have granted the alternative prayer. Then perhaps you would have had
No.
a case that, well, they could have asked for it under section, under section 29.
Now they have asking for section, invoking of section 12,
Yes,
part performance.
yes,
Now part performance is coming when the agreement is separable.
yes,
Clause of the agreement is separable.
yes,
I have read the exhibit 1.
yes.
There is no separable, it is not separable that suppose today no part of share is allowed to be given in any cause. The remaining,
Sorry?
here is the agreement for one, agreement for 2 katha and 7 lecha.
Yes,
There is no such in the agreement that if I fail to deliver the 7 lachas of land, 2 katha will be delivered to me.
yes, yes.
That part performance agreement in the agreement, there
It's
is
not
nothing,
there.
not
Yes,
there.
yes, it's the whole agreement.
Whole
The entire schedule.
entire schedule.
Yes.
So here in this case, since part of the land has been taken over by the government, so
Yes.
question of part performance is not coming under the way. And in this respect, my lord, I want to submit one Supreme Court judgment, my lord.
The other day also you had submitted something, no, one judgment?
That is regarding now not on section 12,
Oh, not on 12.
not on section 12.
Give me. On section 12, you had given.
He has given. Now section 12, when section 12 will be invoked, that is the main consideration. Section 12, in this judgment, the Honorable Supreme Court held that it can be invoked by the appellate court also, but there must be some application that this part is not executable, this part is executable. For that purpose, application is to be there.
Okay.
And here in this case, no such application, nothing. Simply argued.
Yes.
This is judgment Vijay Prabhu versus so and so. It is actually downloaded copy, my lord.
It's all right.
Page 5, paragraph 10.
Yes.
Paragraph 9, section 12 has been quoted. Section 12 quoted. Then paragraph 10. A bare perusal of the aforesaid provision contained in section 12 of the Act make it clear that it is not open to the High Court to direct specific performance of a part of the contract except otherwise provided in section. In absence of any of the exigencies available under the provision of section 2, 3, and 4 of section 12, so as to decree the suit. The word unable to perform suggests that the subsection is applicable only when the party cannot for any reason perform the whole of what he has promised. The inability may arise by any cause whatsoever, including any statutory limitation. The inability to perform may arise by deficiency in quantum of the subject matter or variance in quality, defect in title, some legal provision, or other causes. The expression considerable part implies that the part of which will be left unperformed is either large as regard quantity or as regard quality. In other words, it is material and not insignificant, so that a reasonable objection can be taken by promise to accept performance. The phrase does not admit of the compensation implies that there is no data for ascertaining a fair and reasonable amount as the money value of the difference between what can be performed and the express subject matter of the contract. The amount need not be mathematically accurate if a reasonable estimate of the amount as the money value can be made. It will not be case where compensation is uncertainable. The power to grant partial relief from the very language, this is important, of section 12C of the Act is discretionary. So it is a discretionary. With the court to exercise, keeping in view the facts and circumstances of each case and the right and interest of the parties involved. Section 12C of the Act can be invoked only where terms of the contract permit segregation or right of interest of the parties in the property. In view of the specific finding recorded by the court below that plaintiff was not ready and willing to perform his part of the contract, and the plaintiff being in default, he could not said to be entitled for invoke 12C so and so. In the aforesaid context, we may refer to decision so and so. Then it may be skipped, my lord. Kindly paragraph 20.
So basically, a test has to be a test has to be done to see whether it can be segregated. Whether the suppose see, I don't know. These are things which are coming into my mind, right? In fact, on that day also, what was coming to my mind is that if it's a big chunk of land, very small part has been taken. I do not see why the rest part of it cannot be performed, right? But suppose a major chunk is taken, then of course.
No, that's how
This
it
is
to
how
be.
I am
Yes.
thinking.
How it is to be done?
Huh.
Next paragraph 20 kindly see.
Your Lordship, may I know the year of this?
Mr. Ghosh, please give him the citation.
It's a recent judgment.
No, just give him, otherwise he
Yes,
will not be able to.
Yes,
It's Vijay
I
Prabhu
covered.
versus ST Lajapathe. Take a snapshot of that first page, Mr. Doctor.
Give the citation.
No, citation 9.
The name, party's name.
I have.
Just read out the party's name for their.
Yes, yes. I've got it.
You ask your junior to. You can get a print. Like our photocopy আছে নেকি? Get নাই.
Paragraph 20 minute.
Paragraph
20.
20.
Page 8. In Warmi Singh's case, the defendant number 1 and 2 respectively had agreed to sell so and so specific land. But later on, it was found that they were owners of only 2/3 of that land.
Mr. Datta, paragraph 20 of that judgment is being relied.
In the trial court, the plaintiff insisted on specific performance of the whole contract and prayed that the defendant be asked to make good and deficiency from other land belonging to them. At the time of argument, plaintiff had moved an application claiming benefit of the old section. Earlier, it was old section. Old section 15. In the case, it was held that defendant were incompetent to sell. Here in this case, no such application has been moved. Then it has been held, it was open to the plaintiff to relinquish his claim to any part of the property in a suit on a condition specified in section 15 at any time before the suit is finally decided by the Court of Appeal. Thus, the position of law is that relinquishment could be made at any stage of the litigation, including the appellate stage. The claim of the plaintiff.
Relinquishment would be from the buyer.
Plaintiff. That is the
Correct, buyer.
Then the claim of the plaintiff appellant for grant of benefit under section 12C for the act, therefore rightly not rejected by the High Court, because in this case, before the High Court, they moved an application for relinquishment and claiming part performance. That has not done in this case, present case. So without moving any application, this is a civil suit. It is a continuation of the trial. First appellate stage.
Okay.
Merely by saying that part performance can be done, it is not permissible.
Okay. Copy template.
I will give.
Yes, next.
Readiness and willingness. It is in the merits, my lord, whether they have shown any readiness and willingness. There in the evidence part, there is not a single whisper that they are ready and willing to pay the remaining balance amount of rupees. And suit for
This
specific.
I'm finding
Yes.
difficult
No,
to
not
accept.
difficult. Here is the case, my lord.
Mr.
They will
Ghosh,
have
what
to-
about their, you see, you can go on arguing this point till tomorrow, but at the end of the day, records will speak for itself, right? That notice,
No, not only
that
notice.
notice, their
Pleadings,
prayer,
pleadings
the
and
prayer-
the evidence.
the prayer
Notice
on
notice-
acceptance of balance amount of
No.
rupees 16 lakhs.
that is not exhibited.
You know, the prayer at page 11.
Yes,
What does the prayer say?
my lord, that is the case, my lord. Readiness, willingness.
All right,
only by-
noted.
Yes.
Noted.
Here in this case, no readiness.
According
and
to you,
willing-
there is no
readiness
readiness,
and
no
willingness.
willingness on the part of the plaintiff to return to pay the remaining 16 lakhs.
Yeah.
Noted.
So under such circumstances, suit for specific performance, this appeal is to be allowed and the judgment is to be set aside. Preliminary point also, as well as on merit. This is my submission.
Preliminary point means
That is maintainability.
on the point that you have
Yes.
raised.
Yes.
Okay.
Maintainability.
Yes, Mr. Doctor.
Is your lordship. First of all, I'll take your lordship to the plane at para 10, page 10, para 10.
Para 11.
Para 10.
10.
There specifically we have stated about the second agreement also.
Yes.
So this says that all of a sudden the defendant had decided unilaterally.
Why don't you first read 9?
9. That the plaintiff had let the defendant to know that she is ready to pay the remaining.
The last sentence was that there is no averment.
Yes.
So that's why I'm asking you to read para 9.
Okay. So 9 also and.
Isn't it?
Yes, yes. 10,
9 is an
14.
averment to that effect.
Yes, yes.
So read it loud.
That the plaintiff had let the defendant to know that she is ready to pay the remaining amount of 16 lakh to him. In fact, the plaintiff has collected the said amount and is ready to pay the amount to the defendant.
That all of a sudden, then happened the second agreement.
Yes.
Read.
Then the second agreement, all of a sudden, the defendant had decided unilaterally not to sell the scheduled land to the plaintiff without any reason and executed a deed of contract with the plaintiff on 15/2/19, which the defendant had assured to return 31 lakhs to the plaintiff within the month of April 2019 as per bank rule with interest permission by the bank. The plaintiff had no option but to sign the deed, but for fear of losing such a big amount paid to the defendant. It is also assured by the defendant by the deed at 15/2/2019 that in case of failure on his part to return rupees 31 lakh within month of April 2019, he is bound to execute a registered sale deed as per agreement dated 2/2/17 in favor of the plaintiff. So this 15/2/19 agreement is not a cancellation deed. This simply is the revival of 2/2/2017, the first agreement. That is one argument.
Revival.
Yes, that 2/2/17 is still in existence.
Correct.
They were stating that it has been cancelled by the second subsequent
No,
agreement.
it is not a cancel.
So this is
Because the second agreement also says that all the clauses will remain only in case.
in case we cannot return.
In case they in case they returned it.
Yes, yes.
If they would have returned that 31, which they have taken from you,
Yes.
then that first agreement would have been deemed to have been
Yes, yes,
cancelled.
yes.
I think this is what is the sum and substance of the second agreement.
Yes.
The problem is because they did not return that 31 lakhs as per the terms and condition of that second agreement. Now the question is how the rest of the part will come in. They are saying, ki, well, because you have not paid your 16 lakhs, therefore, that first agreement has also gone and the second agreement continues. It cannot be said that the second agreement is now cancelled. Therefore, unless and until you seek a declaration that the second agreement is declared null, void, whatever, the specific performance of the first agreement cannot be given. I think this is what is being argued on this point. Correct? Now, you pointed out, but to me, what it looks like is that that's why maybe you can read out again that part of the second agreement, that vernacular part. Because what I understand is once they don't return, then of course you will have to pay, because of course then the first agreement remains. Now, if the first agreement remains, all the conditions of the first agreement will also remain. And as per those conditions, obviously you will have to pay your balance, isn't it? And you are, not only that, they have to do their part. So that is how it is. Now the problem is because they didn't do anything of their part. That is how the case came before the trial court. Now here, just because you are not paying the remaining balance, I don't think that argument of their holds. At this moment, I don't find much water in that argument, because it defies the logic, because you have already paid 31 lakhs. And in the initial agreement, there was no time frame. The second agreement, which is only basically trying to get out of the transaction, and in case they cannot get out the transaction, then going back to the terms of the first transaction. It can be only that. It cannot now fasten you with more liabilities and they don't do anything. It cannot be to that extent.
And whether I am at fault for this, petitioner, they are at fault because they have not performed their part. So exactly on that line, the sale part, they have admitted already in the cross-examination part.
But you read that vernacular part once,
yes,
huh?
yes.
I want to be sure in that. Mr. Ghosh, you please give me a translated. Huh? I'm not going to close the. Let me hear you all today. I will not close it. I will fix it on another date. You both, you give me your written arguments as well as the translated. Huh? They have given. You have not given a copy.
That is regarding one point. I'll submit another.
Yes, in fact, it was handwritten. I appreciate your immediately, you may have given it because the matter was today, but it was very difficult for the court to read. Next time, give it in a type and with copy to the other side, please.
Because your lordship have prepared it that day itself.
That is all right. No, it is better than the court than me, I would say. But anyways, please exchange your written arguments with one another. Otherwise, it does not look proper.
I'll type that out.
So I will return it to Ghuraidibo. You take back your written arguments, give a proper one, including whatever has been argued, because arguments will stand closed today. No further arguments. Yes.
Now the second argument, second agreement,
that part
I have converted in.
You have converted?
Yes, yes.
Read.
I'll read the entire agreement.
No, you may just read that part.
The operative part.
That operative part of the second page, which Mr. Ghosh was reading, that vernacular part.
But in January 2019.
Mr. Ghosh, you have your vernacular open in front of you. Yes, now read.
But in January 2019, the first party unilaterally decided.
No, not January, April.
First party shall return the advance money of rupees 31 lakhs received from the second party following bank rules in terms of fixed deposit by the month of April 2019. If the first party fails to do so, the previous agreement of 2/2/2017 will be valid, and the first party will receive the remaining money from the second party. Second party will secure permission from the authority.
This is exactly how I thought it would mean. This is what I thought. But this is what I have understood when you are reading. You give me a translation,
Yes, yes.
proper translated, please exchange.
Yes, yes.
There should not be dispute between you
Between the,
two
yes.
on the translation. Then we'll have to get it translated from the court office, or court translation wing. I don't want any dispute between the councils on this. You both of you can together do it. But I think this is what
There is a
he's read. Otherwise, it looks like it will be similar to that only. It is a continuous process. The first agreement, you go back to the first agreement and pay the remaining, and you complete your part.
Yes.
I think it will mean that only. It cannot be anything else.
Should I read the rest?
No, it's okay. I've understood. আমার translation wing এটা আছে তো?
Yes, yes.
Now I'd like to go to this part performance, which my learned senior was referring to under the TPA 53(4), 53A.
Yes.
Now, first of all, your lordship will see the contents. Chapter 2. This 53A that comes under chapter 2.
Sure. Yes.
So the chapter 2 speaks about transfer of property by act of parties. Now,
Sorry, section?
The chapter 2.
Chapter 2.
Chapter 2, your lordship will find the contents.
I'll go to the index.
Yes, index.
Yes, chapter 2.
So it specifically speaks about transfer
Of transfers of property by act of parties.
So this is specifically in regard to transfer of property. The present case is a preliminary stage. There is an agreement to sell. It is not as if someone's right is there or someone's title has been transferred. So now 53A I'll come again.
Yes.
Where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty. And the transferee has, in part performance of the contract, taken possession of the property. This will be important. Of the property or any part thereof, or the transferee being already in possession, continues in possession in part performance of the contract, has done some act in furtherance of the contract. So this is specifically in regard to transfer of an immovable property. And subsequent to that, the vendee, in this case, me, I have taken over the possession. Then only this part performance of transfer of property will come into the picture. And in regard to the agreement, this is a preliminary stage. Now, until and unless they perform their part of the contract, until they register the sale deed, how can I come into possession? That question will come later on. There only. We are never in possession. So that is the thing. So this part performance in regard to transfer of immovable property will come later on.
Okay.
And section 5 also I'll read, transfer of property.
So you mean to say that the reference to section 53A of the TP Act has no relevance?
Yes.
Because that time hasn't arisen.
Yes.
It is at the agreement to sale stage. Once the agreement takes place, then only the question of transfer will come. And then the question of possession and etc. will
All
come.
All this will come.
It's at the preliminary stage.
Yes. So this will have no application.
But they also, okay, this I've understood. But what about the registration? There is a
registration that is also not necessary in regard to an agreement to sale. Your lordship may come to section 49 of the Registration Act.
In your written arguments, please deal with this
Yes,
argument.
Yes. First, I'll read section 17 of the Registration Act.
Section
17(1)(a).
Yes.
1718 speaks that the documents containing contracts to transfer for consideration any immovable property for the purpose of section 53 of the TP Act.
53A.
A of the TP Act, which I read earlier. Only that will be required to be registered. Not this, they're not speaking about this agreement to sale.
And you mean to say that the agreement to sale is not, since it doesn't fall under 53A,
Yes.
therefore registration is not required.
Yes, not necessary. And further, section 49 of the Registration Act, it speaks
I
about.
think, Mr. Kurz, did you show any authority on this point? 53A, no, no?
This is
53A, did you show any authority? No, right?
I'll submit.
No, but you had not given, no? Any.
Not given because it's new.
No, I'm just trying to
new
understand.
enactment.
I'm just trying to understand.
Yes, new enactment.
That because I remembered you had given 2 cases, but that is not on 53A.
No, yes. It is new enactment, madam.
Now, 49, the effect of non-registration.
Can we read 53A once again?
53, yes.
Because these two arguments are otherwise correlated.
Yes.
If 53A go, 1A automatically goes.
Yes, yes.
Correct?
Yes.
The argument on 1A, registration
Yes.
part. Yes, read 53A again.
Where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property.
The first agreement doesn't talk about possession.
No, nowhere. Taken possession of the property or any part thereof, or the transferee being already in possession, continues in possession in part performance of the contract, and has done some act in furtherance of the contract, and the transferee has performed or is willing to do his part, to perform his part of the contract, then notwithstanding that too, or where there is any instrument of transfer that the transfer has not been completed in the manner prescribed, therefore, by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession other than a right expressly provided by the terms of the contract, provided that nothing in this section shall affect the rights of a transferee for consideration who had no notice of the contract or the part performance thereof. Now, this part performance is specifically in regard to transfer by way of transfer of immovable property, and this is only a sale. And it is not my case that I am in possession. So this will attract only when I am in possession all throughout.
If that sale deed was executed, then this will come in.
Then it will come. So that stage has only not.
All right.
Now, agreement to sale, it is a promise to transfer ownership in fulfilling in the future upon fulfillment of certain conditions. So here it is an agreement to sell specifically, and there is nothing such as for no such thing of transfer of ownership or transfer of rights, of which my learned friend that the other day he has submitted one decision saying that this contract, this agreement to sale, that will be subject to the what do you tell the
Take your time.
that title is necessary for an agreement to sale. So this case is not regarding title at all. So
This is the general, basically facilitating the parties to come into some sort of a settlement so as to enter into a sale deed. It is only that sort of an arrangement, agreement to sale. Otherwise, there's like a booking amount is given so that, and then the formalities are done ultimately to effectuate the sale. It is only basically that stage. Here you have already done your part of your contract by depositing more than half of the sale value, and they have not done the bare minimum what was required from them to get the permission and all that. right? For which the trial court found found you to be willing and ready, and on that account had decreed the suit for specific performance. Now the fact that subsequent to that, the land has been acquired to
No.
that.
To that extent, this 12-2 and the decision which I was relying on that day submitted, your lordship.
Sunil Kumar Jain, I think Mr. Ghosh, you had submitted.
Yes.
That agreement of sale does not confer title. This is the argument that he was
Yeah,
trying to,
yeah.
he was now replying to. Na?
Yeah.
Along with, and B. Santoshama is one I think you had given.
Yes. Now here I'll be
One second, let me just write down the citations as who has given. I'll get confused otherwise. I don't want the wrong citation to be put against your names. Only one you had given last time, or two you had given,
Today I have given two.
and the other day one.
Two.
Where is the other one?
Other one is Karnataka High Court judgment regarding
Oh, yes. Yes, Karnataka High Court, correct.
Yes.
That was on what point?
that is one on the point that when land has been acquired during pendency of the appeal, then they are only entitled for compensation with respect to the performance.
Okay, land. Yeah, affiliate. If this kind of different. I read you na clip at. And today that decision, Dipankar Datta's judgment is on section
It is
agreement to sale, isn't it?
section 34 of this specific relief act,
34.
as well as order 7 rule 1.
This was on what point?
This was regarding if they have not paid for
Okay. Declaration.
declaration. That is the essential part.
Understood.
Judgment pass.
This is
2025 AIR SC 1806. Okay. AIR SC 1806. 2025.
yes.
And another one, Vijay Prabhu, I have given Vijay Prabhu, Supreme Court judgment.
When? Today?
Yes,
Today you gave two.
two.
Where is that?
Vijay Prabhu versus ST Lag.
I think I have it to Pune. I read as a good Foxon.
Correct.
Huh?
Xerox.
Oh, I had given it to him. That's why I'm not getting it. The whole Nigeria. Telugu kara Xerox ko did you? This is on
Whether section 12 can be invoked without any application.
without any application mean?
You will have to file an application then abandoning the claim.
Oh, okay.
Paragraph 20 and 21.
20 and 21.
Yes.
Okay.
And another judgment, my lord, regarding that I have not given, that is with separable or inseparable.
You are giving now?
Yeah. Yeah,
All right, Mr. Datta, you can finish yours.
In this
This is
citation,
para, sorry, just one para.
Para actually, my lord, in SCC, my paragraph is. that
You
main of-
can just write it down and give it
Yes,
to
I-
save the time of the court.
Yes, I'll make it down.
Yes.
I'd like to rely on 2020-19 SCC 80.
Sorry,
2020-19 SCC
2020,
19 SCC
yes,
80.
80. This is, I think you had already given me
Yes,
this.
yes. Relevant paras will be 77.
One second, one. Yes, 71, 72, 73, 87, 88.
Yes.
Yes, let's read that.
I'll start from 68. And before that, I'll go to the specific relief act once. Now, here the specific provision of 12 will apply because the suit we have filed only in regard to specific performance of contract. So the chapter your lordship will find the space under specific relief act. Chapter 2 is regarding specific performance of contract. So under that case, the specific performance in respect of contracts, this will come. So in regard, because during the pendency of the appeal, there was subsequent change. So 12 will attract. So in regard to 12, this citation. Now, para 68.
Yes.
Section 10 of the SRA as it stood prior to its amendment with effect from 1/10/2018 provided cases in which specific performance of contract is enforceable, except as otherwise provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced. When there exists no standard of ascertaining actual damage caused by the non-performance of the act agreed to be done, or when the act agreed to be done is such that compensation in money for its non-performance would not afford adequate relief. Explanation: unless and until the contrary is true, the court shall presume that the breach of contract to transfer immovable property cannot be adequately relieved by compensation in money, and that the breach of a contract to transfer movable property can be so relieved except in the following cases where the property is not an ordinary article of commerce or is of special value or interest to the plaintiff, or consists of goods which are not easily obtainable in the market. B, where the property is held by the defendant as the agent or trustee of the plaintiff. Now, after the amendment with effect from 1/10/2018, section 10 of the SRA provides. Now, after this amendment, this discretionary power of the court has been taken away. Now, it has to be specifically performed. So 10, specific performance in regard of contracts.
That discretion which was shown,
Yes,
I
yes.
think in that decision, it was said it is a discretion.
Yes.
Which paragraph were you reading that?
69.
69. After amendment, it has gone.
The
The word specific of any contract may, in the discretion of the court, be enforced have been substituted with the words specific performance of a contract
Yes.
shall be enforced subject to. The
subject to
court is
provi-
now obliged to enforce the specific performance of a contract subject to the provision of 211.
14 and 16.
Okay.
Now, these are
So
regarding.
relief of specific performance of a contract is no longer discretionary
Not
after the
discretionary.
amendment.
Yes.
Okay. Okay. Yes.
Subject to the provisions of 11, 14 and 16.
Yes.
Now, 71, an agreement to sell immovable property generally creates a right in personam in favor of the vendee. The vendee acquires a legitimate right to enforce the specific performance of the agreement. It is well settled that the court ordinarily enforces a contract in its entirety by passing a decree for its specific performance. However, Section 12 of the Specific Relief Act carves out exceptions where the court might direct specific performance of a contract in part. Section 12 of the Specific Relief Act 1963 is set out here in below for convenience. Now 12 has been quoted. Except specific performance of part of contract, except as otherwise herein provided in this section, the court shall not direct the specific performance of a part of a contract.
That part you may.
Yeah. Now I am relying on 12.2 specifically,
Yes.
where a party to a contract is unable to perform the whole of his part of it, but the party which must be left unperformed bears only a small proportion to the whole in value and admits of compensation in money. The court may, at the suit of either party, direct the specific performance of so much of the contract as can be performed and award compensation in money for the deficiency. So exactly in our case, so much of the contract which is there, that can be performed. And regarding the small portion which is left, regarding that, the compensation which I am to pay, that can be adjusted along with the acquiring authority amount, which has
No,
been
but
determined.
who's going to undertake all this? The suit has already been decreed.
Yes, but this court has the power to modify decree. I have decisions on those also. So this court can takes the role of the original court in a first appeal.
Because the executing court will not be able to,
No.
isn't it?
Yes.
Because with this subsequent development, certainly the decree has to be modified. You cannot get the entire land anymore. Now, in lieu of that, something has to be done. Either your 16 lakhs
Yes.
Can be adjusted from that. But to do that, what would be available before this court? How would this court exercise that power? There's nothing in front of this court.
I have one the judgment passed by the ADC.
Huh?
There the acquiring authority have already paid them the amount.
But these are not evidence before this court. These are not evidence. This is not a writ proceeding.
Some of them, the amount regarding the house and all this on the property, that has already been released to them. And regarding the...
No, Mr. Datta, what I'm asking you is, suppose, assuming this court finally finds your, doesn't find merit in the appeal, assuming. But this court is also is conscious that that decree now cannot be executed to the full extent because of what has happened. The executing court is also powerless. How can they get this decree executed when part of the land has already been acquired by the government? Somebody has to do the modification. If this court as an appellate court has that power, for this court to do that, exercise that power, there has to be certain materials before this court. Otherwise, how would this court modify that decree? There has to be something in front of this court, and that something cannot be some document given across the table, across the bench, because this is ultimately a civil suit. It's a continuing civil suit proceeding. So there has to be evidence.
I can file
I am just sharing what is there in my mind. It has to be, there has to be something in evidence. Those evidence, I don't think is there in right now before this court. I don't think so. You may let me know if they are there already, because the entire basis of giving the relief was whatever was there. It's a specific, but it's not a money suit. There is no such evidence. But now, in lieu of that portion which is acquired, either he will get less money or that entire compensation money has to be given to you. Whatever compensation money he is receiving from that land. I think this is the only way if one has to go that. But how would this, you have to show me.
By way of affidavit, that order passed by the acquiring authority.
Which order?
One order has been passed by the acquiring authority, because they have also brought these subsequent facts by way of an affidavit. So this order...
No, but order, what order? The order is a judicial order. So what order? You give me a copy of that order. That's not a internal document of any corporation.
was passed on 18/11/2025.
This plot is the
Yes,
scheduled
yes.
land, part of the scheduled land.
Yes, 5.4.
You are Sarudhan Ali. Sarudhan Ali. So Jilat compensation of 15 lakh 10,380.
This is regarding Zirat compensation, not with respect to land compensation.
Whereas land compensation of 10 lakhs,
83.
83,187 was assessed for the aforesaid plot of land during the said joint survey. And this amount has not been released till date. So what you want to say, Mr. Datta, is that that part land,
Yes.
which is now no longer available to you under the original agreement to sell scheduled land, is of value of rupees 10,83,187.
Yes.
That's what you want to say?
Yes, yes.
So one way of is that this 10,83,187 can be deducted from the remaining what you have to pay.
Yes. That is one way.
And you'll have to pay the balance.
Balance will.
And whatever available land is there has to be given it to you.
Yes.
But you have to show me that that can be done.
I'll file a affidavit to that extent.
Affidavit what?
That bringing on record this particular order.
This you can file, but this I don't think he's going to object to this. This is
Admitted fact.
this is an admitted fact, and this is a court's. This order is of passed by the additional district commissioner Lakhimpur.
Yes.
This is admitted.
So this anyway, you can put it by way of an affidavit till the next date. It will at least remain in the records. Otherwise, I don't think this can be taken. But how does the court mold that relief and give it now? That is my question. You have to bring authority to show that.
I have certain citations.
Yes. Because merely rejecting will not do. The relief will have to be more in case if I have to reject. I have not made my mind. Only thing I have indicated that declaration, I am not with you as of now, Mr. Ghosh. The rest, yes.
2020 Code SCC 313. I'll read from para 10 of the judgment.
Para?
10.
Yes.
Section 96 CPC provides for filing of an appeal from the decree passed by any order exercising original jurisdiction to the court authorized to hear the appeals from the decisions of such courts. In the instant case, the appeal from the decree passed by the trial court lies to the High Court. The expression appeal has not been defined in CPC. Black Law's dictionary defines an appeal as a proceeding undertaken to have a decision reconsidered by bringing it to a higher authority. It is a judicial examination of the decision by a higher court of the decision of a subordinate court to rectify any possible error in order under appeal. The law provides that remedy of an appeal because of the recognition that those manning the judicial tires to commit errors.
You basically want to rely para 13.
And 13, yes.
Appeal is continuation of the proceedings of the original court. That is, that I understand.
And regarding molding of the relief, Lordship.
Yes, that is where you just have to show me how it is done, that part. Suppose this court, because at the end, I think perhaps and then the moment I deduct this 10 lakhs from the sale consideration, they will be losing a substantial amount. Now, because and the whole reason for doing this is because this amount they are getting for the government in lieu of that land.
Yes.
Which was part of the mail scheduled land. CPC concern?
Mhm. One point four four. This is.
Where the evidence upon the record is sufficient to enable the appellate court to pronounce so and so, the appellate court may, after resettling the issues, so and so, where appellate court may frame issues and refer them for trial. Determination. 27. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documented, in the appellate court, but if the court from which decree has refused to admit evidence, the party seeking to produce additional evidence establishes that notwithstanding and so and so, the appellate court requires any document to be produced or any witness to be examined. So that power the appellate court has. So, I can take this as evidence by way of an affidavit also, isn't it? I can call for this. Requires any document to be produced. That can be done, isn't it, Mr. Ghosh? Under order 41 rule 27B, correct?
Application is to be filed.
Correct.
But at the same time, if it is allowed also, then also rebuttal evidence is to be required to be given.
That's all right. I'm not on that. No, this is an
No,
admitted
only-
document. Right now I'm on this.
On
How
this.
to take this document. Suppose I want to take this document.
Cognizance of
Be-
these documents.
Correct, because you see by immediate, you see what happens, Mr. Ghosh, Mr. Doctor, we can we close the judgments after hearing a case, we close the case. Later we realize that this can be done or that can be done. Then we find that sufficient materials are not available. It becomes very difficult. Now, as the hearing is going on, there can be two outcomes. One, I allow the appeal, matter ends there, no difficulty. But suppose I don't allow the appeal, then obviously the logical consequence is that the decree has to be executed. But now that decree cannot be executed in its present form because part of the land is not available, isn't it? So something has to be done. Now, if I want to do something, then I need some documents. I think this document is sufficient. So this document has to be brought on record. I am trying to find how to bring it on record. I think 27, Mr. Doctor, I think by...
Very clear way, Major, to
Yes.
put it out.
Yes,
Major, the entire amount, how much?
16 lakhs.
Now, the proportionate land which we have been missing, Major, by reducing that portion, whatever amount, Major, they have received, it can be adjusted.
No, that someone has to decide.
Major,
There has to be a...
the parties are
No,
there.
no, both the parties are not going to decide. You come to court for some clarity. Where you are not at, they are not going to decide. Now, if this, the only way is to identify what would be the value of that land, and either way do it. That value of land is available. Is available here.
Yes, is available.
It's 10 lakhs.
So therefore, only monetary compensation has to be decided. That can be easily made because the proportionate amount we are missing. That can be assessed and it can be sorted out.
Then
Now, if Lordship want to send it back, Melody, it will take another 5-6 years.
no, this power the appellate court has.
Please submit, put it around. And I don't think my learned friend has said the rebuttal evidence and all that. In the face of this document,
No, I don't think against this, Mr. Ghosh is going to file his rebuttal against this. This is an amount on this he wants to give any hearing. Of course, I will hear him. But
right
there
he
cannot be any rebuttal evidence to this order of the DC.
In this case, my lord, I don't think there is a question of any rebuttal. Because if we want to say that, we want to prolong the life of litigation only.
Another decision. Here, the apex court has modified the decision passed by the High Court. Here also, during the pendency, the land got acquired and the court had modified. Your lordship may come to 3.2. 3.2 of this judgment.
Give the citation for Mr. Ghosh's.
2021 6 SCC 54. Sukhbir versus Adit Singh. 3.2, your lordship will find High Court accepted the same and after following the decision of this court in Jagdish Singh has modified the judgment and decree for specific performance passed by the learned trial court, affirmed by the first appellate court, and has held that the plaintiff shall be deemed to have stepped into the shoes of the defendant original
So the
landowner.
easiest way is to say shall be entitled to entire amount of compensation.
Entire amount of compensation.
Along with but then the only thing is that it makes no sense to me because you have to pay 16 lakhs, he have to return then that amount. Instead of that, the best option is to deduct and give. I mean thinking it loud. Anyway, we will see whether at all that stage arises or not.
And if affidavit is required to be given, then I'll file a.
My lord, in order 41 rule 27, there is a judgment that it can, if it is filed also, then also it is to be heard along with the main appeal. So I think this document can be considered along with this appeal.
Correct.
There will be no problem.
I'll take that as a submission in the bar.
Yes.
And regarding the evidence portion, that they have specifically admitted that they were supposed to register the sale deed and they were supposed to procure the sale permission from the authority, and they have accepted 31 lakhs. And
This is reflected in the judgment.
in the judgment also, and in the cross, they have specifically admitted.
That is relied by the trial court, I have
Yes,
seen.
Yes.
Anything else?
And regarding this agreement of sale, whether it requires to be registered.
That you have said 7A.
That is there.
That is.
49 also, I'd like to show 49 proviso of the Registration Act. Effect of non-registration of documents required to be registered. No document required by section 17 or for any provision.
Which act?
Registration Act.
Section?
49. Heading starts with effect of non-registration.
Yes.
Of documents required to be registered.
Yes.
No document required by section 17 or by any provision of the TP Act 1882 to be registered shall affect any immovable property comprised therein or confer any power to adopt or be received as evidence of any transaction affecting such property or conferring such power, unless it has been registered, provided that an unregistered document affecting.
So it can be accepted for evidence.
And for collateral purpose. So this is not mandatory. They are required to be registered. And regarding molding of relief, I have one judgment, but that is not present particularly.
You give it with your written arguments?
Yes.
But you give a copy with the list of all the cases, huh? In your argument, you refer to all the cases that you have relied, including whatever you want to, and just give a copy of that additional one. The rest you have given everything, I have it.
We'll also have to file a, this application for additional.
I'm taking that on record right away. So by when would it be comfortable for you, Mr. Ghosh, to, because you have to give the entire thing. He has half of his argument ready. He just has to edit a little more. So when can we have it? But don't take, I mean,
Next week?
next week, yes, because otherwise I will forget. Next week or date? क्या দিব পৰা? Holy নাই জানো next week? Next week or holy বন্ধ নাই জানো? So then
After Holi, 5th?
after
5th March?
holy,
5th
probably
March?
after holy, no, after holy, this bench may
Bench.
not be available here for a week. So ideally, I would like to
Then
finish
9th March?
take it before I go outstation. That would, then it'll be easier for me to complete the judgment.
27
27, it may be kept
February.
27.
27 full time?
is Friday.
মানে কেতিয়া আছে?
Oh,
27?
Okay, 27. Heard Mr. SK. Oh,
another thing,
Yes.
I'd like to point out, in the decision submitted by my learned senior regarding land acquisition, there, the land was acquired before the agreement was entered in.
before the agreement to
And
sale.
in the present case, during the pendency, so that is the major difference. And
You deal with all this in your argument.
My lord, I think in Karnataka judgment, during pendency of the appeal, it was acquired.
and also the entire land was acquired. Here only part.
You distinguish it in your agreement, in your argument. Mr. Ghosh, just the bullet points, basically whatever you have taken me through, just indicate that it then immediately it refreshes. So otherwise I might miss a point. So if I have your written argument, it will help me to reconnect. Heard Mr. S.K. Ghosh, learned counsel appearing for the appellant, also heard Mr. S. Datta, learned counsel appearing for the respondent. During the course of the hearing, in order to find out as what would be the value of the land which has been a land out of the scheduled sale land which had been acquired by the government, acquired by the government would be valuably would be, parties, learned counsels appearing for the parties submitted at the bar that the office of the Additional District Commissioner within bracket LA Lakhimpur has assessed the said scheduled a said plot of land, and the same is of rupees 10,83,187.00. A copy of the order dated 18/11/2025 assessing the value of the compensation of the part subject scheduled land acquired by the government as furnished by the learned counsels appearing for the parties is taken on record and marked as X. So I'm just keeping this on record. And relist did your date to for further hearing. Do you want your citation so that you give it along with your?
No, I have mine.
Huh?
I have.
You have it.
I want the.
Oh, your note. I think, you know what, why don't you sort out these case laws? Take back your own case laws, give it me back along with your written arguments.
I'll submit with it.
It would be easier.
I'll
But
submit.
just give my copies. Don't make extra copies because I have underlined in these copies.
Kept in record, I will submit
Mr. Ghosh, the problem is duplication leads to delay. Then I have to reread those copies again. Now, the only thing is that keeping them like this later on, the moment the file goes, the case loss also gets disappeared. So, ekhani ghurai diok telokok nijor nijor. Datta, you take yours and Mr. Ghosh yours and give it back along with your written arguments. But the same copies, huh? If I don't see my copies, I'm not going to take cognizance of the judgment. Mr. Nath is enjoying it.
Item 20.
You ignore my handwriting though. Yes, that labor case.
Yes, ma'am.
Did you find
Those judgments I have.
Ritz Theatres, Delhi Cloth House? What have you got?
My lord. Lordship, may kindly take this.
Hey,
Because almost the judgment, these are referred, my lord. These cases are.
in Nita Kaplish, everything is referred.
These also I have brought, my lord. The one latest is on 2018. These are all, my lord, referred in those cases.
I read part heard This is the last part heard. Mr. Sharma, you are waiting for which matter?
I am waiting for item number 22.
22,
22, my lord.
where you have filed
I
some
have submitted my
written argument. I said a written argument to Ahila. I think this is another part-heard matter which is going to take time. So maybe you can have your matter on another date. Let me go through the written arguments.
My lord, whether in matter will be taken on 24th.
24th of this
Your
month.
lordship is available because the lordship has.
24th of dictator is the side lesson. 24th? The next kitya dibo para. But that's not part-heard before this court.
Part-heard.
Your matter is part-heard. It's not part-heard.
Just your lordship has asked me to submit written argument.
Kitya dibo para.
About these 3 cases together.
12th March. 12th of March.
12th March. No.
It will likhi dibo. Item, please, what's the item number? 22. In item 22, please take their all names and give it to Pranab. To me, divide.
Must have left.
All right. No, you've been waiting since 10:30. That's why I indicated because this is a part-heard matter again. We actually today there were 4 part-heard matters fixed.
Yes, not definitely.
So this is the last one, but
No, but sitting here, it also helps us, my lord. At least to know something, my lord. Many things, my lord. This is a wide field. It's a very wide field.
yes,
My lord, this judgment, first one is the Cooper Engineering.
yes,
Kindly see the author, my lord.
yes. I am aware of this
Their lordship
decision.
is giving me this judgment only.
In fact, in this decision, there is one line which when I was in your side, I had to suffer a lot because whenever a preliminary inquiry is being challenged before the labor court and that finding is against, and once challenges that in the high court by taking that paragraph from Cooper towards the end, that for whatever worth it may be, it can be agitated at the final stage of the award. All these writ petitions challenging the preliminary award decisions are being set aside. It's not entertained.
Yes.
So it's quite famous.
Yes, I can take that paragraph, my lord. Paragraph 22.
Yes.
This is lordship.
It's in paragraph 22, yeah.
22, yes.
Correct, in 22.
Yes. We are therefore clearly of opinion that when a case of dismissal or discharge of an employee is referred for industrial adjudication, the labor court should first decide as a preliminary issue whether domestic inquiry was violated, the principal natural justice. When there is no domestic inquiry or defective inquiry is admitted by the employer, there will be no difficulty
But when the matter is in controversy between the parties, that question must be decided as a preliminary issue. On that decision being pronounced, it will be for the management to decide whether it will adduce evidence before the labor court. If it chooses not to adduce evidence, it will not be thereafter permissible in any proceedings to raise the issue. We should also make it clear that there will be no justification for any party to stall the final adjudication of the dispute by the labor court.
This part, because of this part.
Yes, yes, that stopped for that, my lord, yes. My lord, so this is basically it is the final, it will be regional court if the intervention stage, yes. In the same judgment,
Yeah.
paragraph 5 can we have a look once. Previous page, paragraph 5.
Yes.
The question posed at the commencement of our judgment is thus highlighted by the aforesaid observation of the labor court, and we are required to consider whether, after labor court comes to a decision about inquiry being defective, it has any duty to announce its decision in that behalf to enable the employer an opportunity to adduce evidence before it to justify the order on the charge level against the workman. This is what.
This is however.
Yeah, in paragraph 7 also, my lord, can you see in the paragraph 7 in between, there's a quoted para.
Yes.
Paragraph 7, there's a quoted para, my lord.
Yes.
The
This
Supreme
is,
Court, last one.
this is from Motipur Sugar. Factory. Yes.
7th line, my lord.
Yes.
From the middle, from the 7th line. From
That
the,
is why this court.
Yes, has consistently held that if the domestic inquiry is irregular, invalid, or improper, the tribunal may give an opportunity to the employer to prove the case, and doing so, the tribunal tries the merit itself. So, in all these cases, my lord, even the next case, my lord, kindly see serial number 2 in my flag mark, my lord.
Yes.
Flag mark.
Nita Kaplish.
Nita, para 18 and 22.
Yes.
Actually, what I understood, my lord, that
Yes.
it is foreign from your lordship the other day. Exactly that's what here in these cases.
No, but how do you, what has happened in your facts? Because what was the impression that has been given on the first day is that the labor court found that the preliminary inquiry was not exhibited or something, and that is why there was no, sorry, the inquiry report. The inquiry report was not exhibited, and therefore it's not valid. I think I think on that.
Yes, yes.
And reinstated.
Yes, reinstated means in paragraph 17, 171 page, lordship will find the inquiry may not be proper. That is the sentence.
And ultimately reinstated.
Reinstated.
Isn't it?
Setting is the reinstated.
Reinstated.
That's what, my lord.
So that is why I was asking you.
Yes.
Now you see, in the event, the court, first of all, the court has to test the validity of the inquiry. But it is for the management. Now here the management has to give its choice. They have a choice. You may say that I want to rely on my inquiry report. If you want to rely, if you say you want to rely on the inquiry report, then the labor court will first see whether the inquiry report is valid or not. Inquiry is valid or not. Simultaneously, you may also say that, well, if the findings goes against me, I may be given permitted to adduce fresh evidence. Now, that is a discretion for you. Now, if suppose you don't do anything, in a situation where you don't do anything, the labor court is not entitled for suo motu calling of evidence.
That's what is disturbing me, my lord, last few days. Because kindly see in all these pages, serial number 3, my lord, flag number 3, can you see?
Yes.
Last page, paragraph 31.
Yes.
Paragraph 31, lordship is paragraph 31.
Of serial number 3.
Yes, paragraph 31. Page number 8, 9, last page.
Yes.
The labor court will now afford the appellant an opportunity to lead evidence.
Where?
Paragraph 31, my lord. Page number, this is last page of serial number 3. Flag 3, last page.
Yes.
Paragraph 31.
Yes.
Labor court will now afford the appellant an opportunity to lead evidence to prove the misconduct alleged by them in the written statement against the respondent, and depending upon the findings which the labor court would record on the issue of misconduct, the issue of termination would be decided in the light of. Now, if I see even, my lord, paragraph 20 onwards, kindly say from 20 onwards. And 24, it is also very clear. we are constrained, para 24, we are constrained to observe that first, labor court committed an error in not framing the preliminary issue for deciding the legality of the domestic inquiry. And second, having found fault in the domestic inquiry, committed another error when did not allow the appellant to lay independent evidence to prove the misconduct charge on merit. Instead, we have proceeded to hold that it was case of illegal retrieval. That is what my case. Here, that's why disturbing me this part. I'm thinking my daughter come over.
No, but you are right. The labor court should have first seen the validity. But I think there are more decisions. Did you get no? Do you have the decision of Delhi Cloth House?
Mentioned here, Delhi Cloth House in one of the cases.
Wait, I think I have taken out.
My lord, in this judgment, kindly see. First one, serial number 1.
One
It is there.
second. 1 second.
Okay.
1 second. It is there in serial number 1.
Yes, serial number 1, paragraph 16, page number 6, bottom page. Page number, sir, at the bottom.
Read. What does it say?
My lord, lordship has got it.
Paragraph?
Paragraph 16, page number 6, numbers are at the bottom, my lord. Delhi Cloth House. Page number 6, paragraph 16.
No, that part of Delhi Cloth House will not be here. 1 second. Just give me a minute.
My lord.
Okay. Read. No, okay, yeah, that's. This is Delhi Cloth House.
Yes.
Even this is 2 judge. Now, the one which you are showing,
72.
even, that also 2 judges. The one which that last serial number that you just showed, Mr. But find out, Mr. Nath, what is the facts there? Because the understanding of the court is that the management has to ask for. And there's another case where it has been said at what stage the management can ask. So when you file your written statement, there has to be an averment that in the event the preliminary inquiry is against you, then you may be given an opportunity to adduce fresh evidence. In that situation, the labor court, it is incumbent, it is imperative on the labor court to give you that opportunity. If they do not give it.
No, in my WS, it is not there.
It is not there.
No,
now, if suppose it is not there, then before the labor court, first thing the labor court has to issue frame a preliminary issue. That here the labor court has not done.
Not done.
So to that I am with you. Now, if suppose this court comes up, if ultimately the court has to hold that, well, because of non-framing of the issue of the validity of the preliminary inquiry, because one preliminary inquiry was done in this matter, isn't it?
No, it was not done here.
No. Sorry.
Domestic inquiry.
Domestic inquiry
Yes.
was done.
Yes.
So that validity was not looked into as a preliminary issue.
No.
So on that, if the court sends it back.
I think, lordship, because when I've gone through all these judgments, I find I could not decide because some of the judgments also fallen from lordships. It is me, the management, who should ask for.
Yes, you have to ask.
But
that line is there.
But flag number 3, paragraph 22, lordship is, see, my lord.
See, there we don't know. Maybe in the written statement somewhere that averment is there. Because I can give you at least 3 decisions where it says that it is for the management. This is Delhi Cloth House. I'll just read it out quickly.
My lord.
Before we deal with the decisions in State Bank and so, it is necessary to refer to 3 earlier decisions of this court in Bharat Sugamil so. Anyway, that is not so important. when an application for permission for dismissal is made on the allegation that the workman has been guilty of some misconduct for which the management considers dismissal the appropriate punishment, the tribunal has to satisfy itself that there is a prima facie case for such dismissal. Where there has been a proper inquiry by the management itself, the tribunal, it has been settled by a number of decisions of this court, has to accept the findings arrived at it in that inquiry unless it is perverse, and should give the permission asked for unless it has reason to believe that the management is guilty of victimization or has been guilty of unfair so and so. So should give the permission asked for. Okay. But the mere fact that no inquiry has been held or that the inquiry has not been properly conducted cannot absolve the tribunal of its duty to decide whether the case that the workman has been guilty of alleged misconduct has been made out. The proper way for performing this duty, where there has not been a proper inquiry by the management, is for the tribunal to take evidence of both sides in respect of the alleged misconduct. Okay? When such evidence is adduced before the tribunal, the management is deprived of the benefits of having the findings of the domestic tribunal being accepted as prima facie proof of the alleged misconduct unless the finding is perverse and has to prove to the satisfaction of the tribunal itself that the workman was guilty of the alleged misconduct.
Yes.
Meaning thereby the management cannot rely on the findings of the inquiry officer. He has to adduce fresh evidence. We do not think it either just to the management or indeed even fair to the workman himself that in such a case the industrial tribunal should refuse to take evidence and thereby drive the management to make a further application for permission after holding a proper inquiry and deprive the workman of the benefit of the tribunal itself being satisfied on evidence adduced before it that he was guilty of the alleged misconduct. It must, however, be pointed out that it is not clear from the facts mentioned in the judgment as to when the findings regarding the defective nature of the domestic inquiry was recorded by the tribunal and at what stage, this is important, the management adduced evidence before the tribunal. But one thing is clear, namely that the management adduced evidence before the tribunal when the proceedings were still pending before the tribunal. And later on that line only it has gone here. And ultimately, those 7 principles have been held here. It started from the Delhi Cloth House. You have a copy of the Delhi Cloth
No,
House?
I've not got, because it was quoted, so I didn't bring that one.
Having due regard to the above principles, as could be gathered from the decision referred to above, in our opinion, the application filed by the management for permission to adduce evidence was highly belated. So, you see, that application has to be filed. No, you have to file that application at the initial stage, not after the preliminary inquiry is held to be not proper.
Yes,
Not at that stage.
Before.
Before.
Yes.
Before.
Yes, this is not there.
This is not there. That is one thing. So this is very clear.
Factually very correct.
This is what is there in Delhi Cloth House.
Yes.
And there's one more decision where exactly this thing was said. Yes, this is Britannia Biscuits Limited.
Which year, my lord?
Wait, this is, I think I got that decision as well. Yes. This is 1979 3 SSC 371. Para 34. Mr. Nath, maybe Mr. Bora can read out loud for all our. Did you? Para 34 of Britannica.
These are two things actually. Was
The
bothering
two things, one validity and this, because there cannot be a suo motu direction to the parties to
But in
adduce
Kaplish,
evidence.
in Kaplish case, in paragraph 18,
I know.
yeah,
It
legal
is
position
mentioned.
has emerged out is that in all cases where the inquiry has not been held or the inquiry has been found to be defective, the tribunal can call upon the management too. What does it mean, my lord? Call upon the means it is a tribunal.
We'll come.
That's what is disturbing actually, my lord.
Yes, read that.
Yes, my lord.
Read from there. You said, Mr. Nath. You sit down.
The employer terminates the service of a workman. That termination raises an industrial dispute either by way of an application under Section 33 of the Act by the employer or by way of a reference by the appropriate government under Section 10. If an application is made by the employer as it is required to be made in the prescribed form, all the facts are required to be pleaded. If a relief is asked for in the alternative, that has to be pleaded. In an application under Section 33, the employer has to plead that a domestic inquiry has been held and it is legal and valid. In the alternative, it must plead that if the labor court or industrial tribunal comes to the conclusion that either there was no inquiry or the one held was defective, the employer would adduce evidence to substantiate the charges of misconduct alleged against the workman. Now, if no such pleading is put forth,
So this is exactly in your case.
Yes,
yes, my lord.
You just, can you underline that part?
Yes, my lord.
Now,
The employer would adduce evidence.
though this will go against you,
Yes.
looks like.
Yeah, no, looks like yes.
Now,
But those that
Now, if no such pleadings is put forth either at the initial stage or during the pendency of the proceedings, there arises no question of a sort of advisory role of the labor court or the industrial tribunal, unintended by the act to advise the employer, a party much better off than the workman, to inform it about its rights, namely right to lead additional evidence, and then give an opportunity which was never sought. This runs counter to the grain of industrial jurisprudence. Undoubtedly, if such a pleading is raised and an opportunity is sought, it is to be given. But if there is no such pleading either in the original application or in the statement of claim or written statement, or by way of an application during the pendency of the proceedings, there is no duty cast by law or by the rules of justice, reason and fair play that a quasi-judicial tribunal like the industrial tribunal or the labor court should adopt an advisory role by informing the employer of its rights, namely the right to adduce additional evidence to substantiate the charges when it failed to make good the domestic inquiry, and then to give an opportunity to it to adduce additional evidence. This, apart from being unfair to the workman, is against the principles or rules governing the procedures to be adopted by quasi-judicial tribunal, against the grain of adversary system, and against the principles governing the decision of a lease between the parties arrayed before a quasi-judicial tribunal.
So no suo motu opportunity to the
this case
management.
was discussed in serial number 2. Kindly look at serial number
In Kupa?
Yes.
No, in Nita Kapli.
Nita.
Nita Kapli.
Yes,
Yes, I know.
Para 16, 17, 18. Just
Yes,
no,
yes,
I'm just for clarification.
Yes.
But this is what, my lord, in two types of things.
No, it's not two types of thing. It is, you see, in all the other decisions, Mr. Nath, nowhere the apex court has said at what stage this has to be called. The issue first arise in Britannica.
79, yes.
That the suo motu calling will not be there.
There has to be an application by parties.
There not necessary application. A request is also fine enough. There has to be that has to come from the management.
My side.
Yes, and at an appropriate stage. if I have to read all these decisions together,
This is the conclusion.
this is how I
This is the
understand.
cream.
Yes, it has to be at an appropriate stage, not after the preliminary inquiry is decided against the management.
Yes.
So anytime during the proceeding, even at the stage when the preliminary inquiry validity is being heard, at that stage also the management can say before the hearing that, well, in case this goes against me, I may be allowed to give my evidence. And the tribunal in that situation has to give you that.
Yes, they can't say no.
They cannot. Simply because they said that no, the inquiry is bad, they cannot straight away direct reinstatement. That cannot be done. But now in your case, if I understood correctly here, because of that exhibit, not proper and reinstated. Direct.
Saying
Right.
the inquiry is not fair. No, my lord.
That part obviously is wrong. But suppose even at this stage I send it back. Ultimately, you will have to bring in, if you don't have the original, we don't know, but this is not civil proceedings.
Yes.
These are not civil proceedings.
No, this is beneficial.
Correct. So the
Spirit.
the inquiry officer has to be brought in the evidence.
I think, Lordship, ultimately, I think I'll have to make a plan and that way. Let me just make
No,
submissions.
but there now you cannot file that application
No, I cannot.
saying that if this goes against me, I may be allowed to adduce evidence.
No, kindly just
Because already this inquiry, perhaps I don't know. I may not go to that
but
extent
one
in
thing,
this
my lord,
proceeding.
but one thing,
but
once this part, but just let me finish
we'll
this
get
one, my lord.
Nita Kalpesh. Yes,
Yeah,
you want to
paragraph
show me
16, 17 and 18,
one
page
sec-
12.
one sec. We will see that. Paragraph
16, 17, 18. 16 is Britannica. Exactly what is foreign film lordship is there.
16.
Yes, page number here. Numbers are bottom right. Page number.
What has happened actually, Mr. Nat, several times, these hard copies are there in my chamber. So, in fact, Ritz Theatre, I remember
Yes, I have
half of my half of the paper, that
bunches.
portion of the paper is torn also.
By markings.
So every time now I look into these photocopies, I can't connect because it's
Yes,
easy
there.
the mind is there in
Yes,
those.
yes.
I still remember the color of the highlighter I've used in Ritz Theatre. It's
That's
orange.
easier, my lord, to connect.
Yeah, so I can immediately connect.
Yes, that's true. That's true.
I can see a lot of young lawyers in the back. I'm sure they will not relate to what I'm saying because they are more used to look into the soft version. They are not used to looking into the hard copies anymore.
No, but I find
But nothing like looking into hard copies. It's very easy to connect.
Yes, once you mark it, my lord, you can remember I've given that mark there.
Yes. What do you want to show from Nita Kaplesh?
That paragraph 16, Britannia biscuit has been.
Yes. Please read.
This court observed that right of the management to adduce additional evidence must be availed of by making proper request for the purpose.
Exactly.
Which may even be contained in the pleadings or maybe at the time before the proceedings are closed. The court observed that if such a request is made in the pleading itself, the tribunal has to give an opportunity to the management to read. Exactly. Next. Bharat Fortune, my lord. Another one, my lord. United Planters Association. It was laid down that labor court or the tribunal can take fresh evidence on merits of the charge if it comes to the conclusion that domestic inquiry was not properly held and principle of natural justice is violated. And then para 18. In view of the above, the legal position as emerges out is that in all cases where inquiry has not been held or inquiry has been found to be defective, the tribunal can call upon the management or the employer to justify the action taken against the workman and to show by fresh evidence that termination of dismissal order was proper.
That is the concluding part, but the question is request.
Yes,
if this request is not done, then
no, that's what I was.
Then what will happen?
No,
that is something.
Suppose, my lord, what I'm just feeling, my lord. Suppose that my request was not made in this case, lordship is seen, my lord. Now the labor court has given a judgment on merits now. Now,
so that too he cannot.
He has given the merit.
That is why I am going to set aside this award.
That's what I'm saying, ma'am. That's why.
This award, Mr. Nath, perhaps cannot stand. I'm quite sure of that after hearing you for last 2-3 days.
Exactly, my lord. And
But the problem is what is to be done? This
once-
is the reason I
once
am.
this goes back, my lord,
Yes.
that's my lord. To be very honest, sitting there, I was telling my colleague there that these judgments, I have come to this conclusion. Then what? I'll ask the honorable court to decide because I am not getting ideas, my lord.
So that is exactly
That's
what,
what I was
what
telling my
stage
friend
will
there.
it go back to? Because you have not made a request.
That is not there.
You have not made a request. The labor court has already held that the inquiry is not proper.
Yes.
But what I find is that finding of the labor court is merely because the inquiry report was not produced. The photocopy was produced?
No.
Nothing
No.
was produced.
But but they could have, labor court had got the power.
No, we are not on that. But then on what basis?
There is another reason. Once the labor court has said,
Mr. Nath, on what basis did you say that there was an inquiry? The inquiry report was not produced.
No, it was
Any
not.
evidence produced?
Evidence was there, everything was marked, my lord.
Evidence was on merit.
These are on merit, these are all marked, my lord. They are the
No, in that case, that means you have given up your inquiry.
Evidence, we have
You
given
see,
the fresh evidence, yes.
No. You see, in that case, the third principle of Cooper and Delhi Cloth House might come in. If you have adduced evidence on merit, what evidence have you adduced?
My lord, just have a look.
Regarding the domestic inquiry?
That's what, entire domestic inquiry.
Not on merit.
Not on merit, that one. How it is conducted, my lord. What happened? In spite of receiving various notices, he turned to the, turn up to
Where do I get these evidence?
It is there, my lord. Lordship can see in the trial court judgment. And also, my lord, lordship is 76, 70 to 8, my lord. Workman evidence. And the evidence of, my lord, our evidence is page number 142.
Of the trial court records?
It is there. And also in there, here also.
Where? Page?
My lord, in our evidence, lordship can see, my lord, that's in page number 160. 142. 142. 142. The entire evidence is regarding the inquiry, my lord. Let us see. 142. Here it is a detailed statement. How it happened, when notice was given to him, he has replied that medical certificate, my lord. The issue is what? Issue was he didn't report to the, my lord, for in the mill. Then he,
so no evidence on merit.
Not merit. This is the kind of domestic inquiry only that he received the notice, he didn't turn up, my lord. All these things, my lord.
What do you have to say, Miss Kalita? Kalita, na?
As per I also studied the judgment, domestic inquiry is the legal point for preliminary and disciplinary inquiry for misconduct. And in this judgment, domestic inquiry is missing. Therefore, Honorable Court, if send back the matter, it will be legal. Because I will face the domestic inquiry. What is the report?
Why was the domestic inquiry report not produced before the labor court? It's not there.
I got the copies with me. I don't know, my lord, the counsel or what. I was surprised, my lord. Then I remembered, my lord, the ECIL case. Because ECIL cases said that Ramzan Khan inquiry report must be furnished. ECIL said in some of the cases, even if you don't furnish the report.
No, that's different. That is for the delinquent. If you are cases that you have hold an inquiry, a domestic inquiry before the labor court, what will the labor court see? The labor court has to see whether the domestic inquiry report.
That's what I'm saying.
Correct. The proceedings has to be in front of the labor
Yes,
court.
that's what.
If the proceedings are not given to the labor court, how they can?
No, I'm not talking about. I'm talking about the person about.
The person is all right. I'm not on that.
No, labor court has not seen that one, my lord. No.
Here,
that's the reason. Labor court says, my lord, because this was not
proper.
Given, presumption he has done. 114 was evidence check, and the FS court says no. For non-furnishing the documents, you cannot do presumption now on 14. It is the judgment I have given serial number 4.
Not given to whom? To the delinquent.
Court.
To the court, no.
Yes, to the court. To the court.
See, Mr. Nath, I'm repeating myself again. To that extent, I'm with you.
Then thereafter, my lord, I'm also thinking, my lord, how to come over that, my lord, that barrier there.
There is one judgment of Justice B.K. Sharma Please try and find it out.
The other day had it, my lord. I'll get it.
I may have been in your place, in your shoes that time.
Find out. I think probably I went off one.
You also find out, Mr. Goswami, B.K. Sharma's judgment.
My lord,
Related
other
to
day I had it, my lord.
maybe it's a Goodrick Tea Company case, Amguri or something, probably.
My lord, the other day I read it, my lord. I think it was once.
But there maybe that request was there in the pleading, but some clue might come. We might get some clue from that decision.
This case, only because of the last portion, my lord, I'm lost before thinking, my lord, how to come about that barrier there.
We'll have,
My lord, I got that.
you have B.K. Sharma's judgment?
I read the other day, my lord. It was in my other file. It was also
You have given me your written arguments, no? You have given?
I have given, but my lord, that was on a different content, on the factual and the judgments given by that one.
That's all right. On the facts only I wanted.
Yes, yes.
क्या था वो पॉइंट? Mr. Nath, we will have put it on another date.
Yes.
You get hold of that judgment as well and
I read that one. I
rethink. Let me also look into these judgments that you have placed.
I was telling my friend that here I got stuck up. Then I thought I'll ask you, pay to learn.
So there are 3 judgments which talks about the stage. That is, Britannica is one, which again Nita Kapilesh also affirmed.
Yes, yes, yes.
Now, if that be so, obviously here it's an admitted position that you have not made such request.
Yes, Kurukshetra.
You have not made any request.
No, that is sure.
That is an admitted position.
Admit fact, this is my lord. Fact is fact, my lord. I can be twisted.
All right, we will see. We'll have it on another date.
But on May 26th, Thursday.
26th
is a Thursday.
26th.
I checked the date.
A 2 week or. All right. Heard Mr. M. Nath, learned senior counsel assisted by Mr. D.P. Bora, learned counsel appearing for the petitioner. Also heard Ms. A. Kalita, learned counsel appearing for the respondent number 2. Respondent number 4 and Mr. J.K. Goswami, learned additional senior government advocate for the state respondent. Mr. Nath, in support of his contention that the learned labor court ought not to have ventured into the merit straight away after holding the inquiry not proper, relied upon various judgments rendered by the apex court. Upon a pointed query as whether he further submits that it is imperative for the labor court to go into the to give opportunity to the management as well as the workmen to adduce fresh evidence in the event the inquiry is found to be not proper. In the present case, it is indisputed that no request at any relevance stage has been made by the management seeking an opportunity of adducing fresh evidence in the event the inquiry held by the management is found to be defective or not proper. Upon a pointed query as whether the labor court is required to suo motu give the opportunity to the parties for adducing evidence, Mr. Nath seeks a short accommodation to further look into the aspect. relist on such and such date. I am not said Britannica right now because
Yes,
this is
sir.
what I have got it. I have already given you the handle.
Yes.
Now you look into it
Yes.
because you see that is very old. There are, I'm sure, not only Justice Sharma, there could be there. However, Mr. Nath do not bring a lot many cases. That get one or two cases. Try and get Mr. B.K. Sharma, and there could be one of Justice Sham, a recent one where a lot many cases perhaps have been referred to, on this point.
Right.
Because what is now required is whether
Last point we got stuck.
whether that sumoto giving you that opportunity.
Yes. Suppose is it not permissible, then what step? Since the inquiry.
Because
started.
I remembered in Justice B.K. Sharma's that case, the Labour Code had directly gone into merit after saying the inquiry natural justice have been violated.
Like my case.
Like your case. And then matter was sent back because the court says, no, you can't straight away go to merit. You have to give an opportunity first. But the question is, most likely in that case, a request was there in the pleadings. But in your case, that request is not there.
That is disturbing me.
Now, if suppose that request is not there, then what is to be done?
At the same time, when the lawsuit will find that judgment passed by the Labour Court was out and out.
So in that situation, even if I send this matter back,
what is done?
What will happen?
Yes.
So some more clarity is required.
Yes. I got actually this point I got stuck up actually.
All right. Relist on such and such.
My lord.
For further hearing, part third. Yes.
My lord, item number 35.
Yes. When do you want it, Mr. Sharma? There'll be no time now.
If possible.
Next week, many matters have been already fixed. Unnecessary, it may not reach. You take it after that week. Give the next dates were after. Because unnecessarily you'll have to wait, Mr. Sharma.
Yes.
Let us finish all the part thirds first.
Obliged.